Good morning, everyone. I would like to call this meeting to order. This is our third meeting for our joint interim Judiciary Committee. We will start with roll call first. So Ms. Jacobson, will you please call the roll? And anyone that is not present right now, please mark them present when they arrive.
Senator Harris.
Present.
Senator Krasner. Senator Scheibel. Assemblywoman Gallant.
Present.
Assemblywoman Gonzalez. Assemblyman Gray. Assemblywoman Marzola.
Present.
Chair Miller.
Here. And again, Ms. Jacobson, please mark members present as they arrive. Just a few housekeeping issues. We are able to start because we're not actually voting on anything today. The only thing we'll be voting on is the minutes. So we will, that's the other point of housekeeping. We're taking a few things out of order today on our agenda. But just want to remind folks, those that are members that are joining us virtually, please keep your camera on so that everyone is aware that you are here. Also, for everyone, please make sure you turn off the sounds and alarms and everything else going on your devices so that we don't have anything disrupting. Reminding everyone that materials for this meeting are on our committee webpage on Nellis. As I stated, we will be taking the agenda out of order, so those that would like to keep track, the first item we will do today will be item 12, and then from that point we should do it in a sequential order, but we will be beginning with agenda item 12 today. Again, just want to remind people that members are looking at laptops and devices and such, and that's for research and all the materials that we're going through. Please do know that we are still engaged. It's not, and don't take that as a form of disrespect because we have a lot of things that we're reviewing up here. We will have two sections of public comment, one at the beginning of the meeting and one at the end. At some point today, we will break for a 30-minute lunch. And with that, we will go ahead and begin public comment. Just a reminder to everyone, there are a few different ways that you can make public comment. First, you can call, well, I should say first, you can present in physically presence here or in Carson City. Additionally, you can also call in. The phone number is 1-888-475-4499. The meeting ID, when prompted, is 871-9836-0408, and then you will press pound. And someone from Broadcasting and Production Services will indicate when it's your turn to speak. You can also submit written comments. You can email them to judinterim@lcb.state.nv.us or mail them to the Research Division at 401 South Carson Street, Carson City, Nevada, 89701. Again, we ask that anyone making public comment try to limit their remarks to 2 minutes. And of course, sometimes we do understand that you have a lot more than 2 minutes worth to say, and that's a great opportunity to also email us your remaining remarks or mail them to us. With that, we will go ahead and start public comment. So I will first start here. Broadcasting, go ahead and please open the lines. I will first start here in Las Vegas. Is there anyone here in Las Vegas that would like to make public comment? You would please come forward. And also, if there's anyone there in Carson City that would like to make public comment, also you may approach. Ma'am, you can come right up to the table. Oh, okay. So come right up to the table. Please have a seat. And then there's a button there that will say, it should say mic, and you can press that. We will ask that you state your name and spell it for the record. And then you will have about 2 minutes to make comments on anything you'd like to share with us. Okay, so when you are ready, please begin.
Hi, my name's Deanna Hagenberger, D-A-N-N-A
Hagenburger. Good morning. I'm here today in light of the recent events with Dennis and Ashley Prince and several experiences of my own and others. I was referred by somebody to come here and speak. I am here today to collaboratively make so much needed changes to our family court system for the greater good, safety, and health of all people involved in the court system. Every family law attorney I've talked to in town, and I've talked to a lot of them recently, all said the same thing: the system is broken and we need to fix it. Few quick personal experiences. Through my divorce case, I had a judge that was retiring, made a lot of decisions that didn't follow Nevada law. There was fraud in my case. The math wasn't done correctly. I'm going to just say this quickly since I have 2 minutes. A lot of things went wrong in that situation. A year later, or a couple years later, I talked to another attorney. He said, no way you spent $150,000 on that case between your custody battle and your divorce. And I said, he asked me who the judge was. He said, of course you did, because she didn't want to work for the last 2 to 3 years of her career. On next to the abuse my children went through, a retired captain of Metro. My son reached out to him for abuse, and the captain said, this is how murder-suicides happen. He reached out to me and said, you need to get a restraining order, which I did. They would not allow him to testify in the case, and 30 days later, they removed it. For a long court battle, we had excruciating experiences. My 3 amazing sons did 6 hours of testimony about their father and everything that was happening to him. Kicked indoors, thrown across the room, abuses on the legs. My son thrown in the shower, almost hit his head, verbally abusing. A lot more. The judge was in tears listening to the child testimony and ultimately kept my kids in that environment and said, let's do therapy. There was a point that my kids did not deserve this. This environment wasn't safe. We had hundreds pages of documentation, abusive manipulation. For 2 years continued, and my ex sent me several threats that he was going to hurt me, that he was going to do all kinds of things to me. It went on and on and on. My ex had stalkerware on my phone, which at the time I was not aware of. I had told somebody in my fear that he was going to kill me, and then my kids would be left without a mom. About 3 hours later, I received an email stating that over my dead body would I kill you to ruin my life. I found out 2 years later that there was stalkerware on my phone, so he heard and listened to everything that I had said. As illegal and wrong and abusive as that is, it actually probably saved my life. The reason I'm passionate about this is that I have known Ashley Prince since her case started, and she went through many of the same things, so we bonded and we talked about it. The short version of this is that there's a lot of things that happened in the case that I feel could have been handled differently. I understand that being a judge is part of interpretation, but when there's facts in a case and there's things that have happened wrong continually over and over and over again, something needs to happen in that case, and things need to change. For the family's sake, for the abuse is permanent. It can end up in several different avenues. My kids still have permanent repercussions. I got lucky. My kids still have a mom. But I think this case is an example of how we need to make a difference in this system. I think there's a lot of options. When you have facts that somebody is drinking and they don't pass their breathalyzer and nothing happens, several people have said that the case wasn't addressed. It carried on too long. It wasn't handled. The judge even admitted that. There's been comments that it's been let down. I'm shortening this because I have supposedly 2 minutes. It's probably done. But a lot of the comments are this tragedy is monumental portions. I have a sad feeling nothing is going to change. The family court is retrievably broken. What happened is not a surprise for longtime family practitioners. It was never a matter of if, but when. Family court is full of judges who reward bad behavior of certain attorneys, and so it continues. Some possible solutions: judges should not be elected; they should be, recommended.
Ma'am, you know what would be more helpful for us if you have those suggestions, if you could submit those to us.
I do,
because we would be very interested in hearing the suggestions.
Okay, I have a lot.
Then it will be even more helpful if
I'm passionate about this because I experienced it,
yes.
And I just want good change
yes.
for everybody that gets involved in the family court system in Nevada.
Yeah, so if you could email those comments with the suggestions to the committee, that would be very helpful.
Okay.
And appreciate it. And again, it goes without saying that the recent tragedy and loss that happened, it really did shake the legal community, and So thank you for sharing your comments and your experience, and please submit your suggestions.
I will, and thank you for your time. I
Thank you
appreciate
so much. Thank you. Is there anyone else here in Las Vegas? Not seeing anyone, we will move up to Carson City. Sir, do you have public comment?
Yes, good morning. I am Edward T. Reed, and I'm a retired Nevada attorney and member and vice president of the organization Advocates for the Inmates and the Innocent. And my president is sitting right next to me here. On behalf of the advocates, I would like to express the advocates' full endorsement of the second look sentencing agenda, which was presented at your last meeting in February by a representative of Families Against Mandatory Minimums. We are particularly interested in crafting laws and supporting possible legislation that will allow a second look for individuals sentenced to life or life without sentences for crimes committed when they were emerging adults or between the ages of 18 and 25. Some relatively recent U.S. Supreme Court decisions, in particular Miller v. Alabama from 2012 and Montgomery v. Louisiana from 2016, recognize that the brains of young people don't fully develop until they are around the age of 25 years of age, which makes them, quoting from the Montgomery case, quote, more impulsive to peer influence than older adults, and less able to inhibit inappropriate behavior, manage intense emotions, and fully consider consequences of their behavior. In view of those considerations, and to its great credit, this legislature in 2015 enacted NRS 213.12135, which allowed for a shortened eligibility for parole of individuals convicted of serious crimes for acts committed when they were under the age of 18. We, advocates for the inmates and the innocent, as a stakeholder, hope to work with the upcoming legislature and FAM to enact second look legislation in the state of Nevada. Thank you.
Thank you so much. Is there someone else there in? Please proceed with your comments.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. Good morning, Chair Miller and members of this committee. I just want to bring to your attention, in January of this year, the first meeting, we brought to you asking and suggesting to give a presentation. We submitted our email to the legislative to Ms. Jacobson and Ms. Thornton, along with Senator Scheibel, asking to have an agenda for April. Unbeknownst to us, that in February, that FAM would be giving a presentation. We also had submitted in January what we were asking for, which was to have a discussion and getting laws created on emerging adults. Anyways, recently I have spoken with Mr. Daniel Landsman with FAM, and we had a great conversation, and I just wanted to let you know that he and our organization would like to work together moving forward with this legislation for 2025. And so I just wanted to let you know that, and so hopefully you will take this recommendation. We brought it to you in January. In fact, I even brought it to the Sentencing Commission back in November on this, because particularly what had happened with the Pardons Board and how the Pardons Board's hands were tied, and they were, because they couldn't release and pardon a certain individual, an inmate by the name of Sally, I'm sorry, I can't think of the last name, Villaverde. Sorry, Sally Villaverde. They brought him back to the Pardons Board twice, and because of the laws, they couldn't let him go. And so that became an issue as well. So we ask that moving forward, that laws be created to help these between the ages of 18 and 25, giving them a second look, looking at these sentences. People should not be in prison for 20, 30, 40, 50 years longer, because their brain had not matured, and we are sentencing on them prior to that. So we should go by what the study shows, research shows, and 25. And those should be the cases that we also look at. Thank you.
Thank you so much. Is there anyone else there in Carson City that would like to make a public comment? Okay, not seeing anyone. Broadcasting, is there anyone on the line?
Yes, Chair. If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you have recently joined and you would like to provide public comment, please press star 9 now.
Anne Marie Grant, ANNEMARIEGRANT, Advocates for the Inmates and the Innocent. I just want to echo my colleagues' sentiments and reiterate our vested interest in participating in second look sentencing reform. Thank you.
Thank you, Ms. Grant.
Chair, there are no other callers at this time.
Okay, thank you. Then I'll go ahead and close public comment. Again, there will be another opportunity for public comment at the end of today's meeting. We will move on to agenda item 3, which is the approval of the minutes for the meeting that occurred on February 23rd. Members of the committee, are there any questions regarding the minutes? Not seeing any, I will entertain a motion to approve the minutes from February 23rd, 2024.
So moved.
I have a motion from Vice Chair Scheibel. Do I have a second?
Second.
I have a duel. I'll take a second from Assemblywoman Gonzalez. And with that, is there any discussion? Members, all those in favor, please say aye. Aye. Anyone opposed?
Aye.
Aye.
Thank you, and I'm hearing our ayes from Carson and virtually. With that, is there anyone opposed? Not seeing any, the motion carries. Thank you so much for that. With that, as I stated, we will be taking agenda items a little bit out of order, so we will begin with agenda item 12. Again, as you notice, we have a very robust agenda for today, so I ask that presenters, and I shouldn't even say presenters because I know sometimes we have multiple presenters for an agenda item. So, but that the agenda item, the presentation, be kept to around 15 minutes. And I would also, as a point of privilege, like to dedicate today's committee meeting to in honor of Sharon's memory. So, with that, we will start with our first presentation, which is by the District Attorney of Juvenile Division System. We're going to have systems overview, statistics, and legislative review and priorities for 2025. We have the Director of the Juvenile Division from Clark County District Attorney's Office, Bridget Duffy, and we also have Shelley K. Scott, Chief Deputy District Attorney from the Juvenile Division from Washoe County District Attorney's Office. So, Ms. Scott, there you are. All right. So, when the two of you are ready, please proceed.
Good morning, Chair Miller and members of the Interim Committee on Judiciary. I am Bridget Duffy. It's BRIGID-DUFFY. My title is Assistant District Attorney of the Juvenile Division for the Clark County District Attorney's Office. And I will run you through the Clark County slides, and then I'll kick it up to my counterpart in Washoe County, and then I believe we'll answer any questions that you may have. And please, thank you. I would like to say very much thank you for putting us earlier in the agenda as a courtesy to me. Thank you so much. I did not want to miss out on presenting, and you have no idea how happy I am to be here today to do this for you.
Ms. Duffy, when you say courtesy to you, it makes it sound like favoritism. So
I'm so sorry.
Okay.
I'm so sorry.
Just,
it's just a term I use.
Right.
It was not favoritism, I'm
Can't
sure.
put everything at 9 o'clock. I'm just teasing you. Please proceed.
So this is just a quick overview of the juvenile delinquency process. You can see how we run through cases. Kids come in through arrest or citation. They are either Is that better? Okay, got it. That's showing now. So arrest or citations, those are tickets. Misdemeanors by statute, they can all be diverted away from the eyes of the district attorney's office. So we do not see a lot of the misdemeanor citations or arrests that come through. Gross misdemeanors or felonies are funneled a different way. All types of entry points, arrest or citation are seen by probation officers. Those that can be handled informally under statute are handled informally. Those that may not be are seen by the district attorney's office, and then we will decide whether or not we would like them to be handled informally or if we will be filing the charges. So that's just kind of your flow chart to help lay some foundation for the next few slides. So in my division, which I've proudly run on behalf of the district attorney for the last 12 years, I have approximately 63 employees when I am fully staffed, and 29 of those are deputy district attorneys. 9 of them are assigned to the delinquency side, which is what I'm presenting on today, and the other 20 are for the child dependency side, or those cases that come in through the child welfare system. Clark County District Attorney's Office actively participates in 5 diversionary type programs. We have the harbors, which are our juvenile assessment centers. There are 5 of them in Clark County. We have day court, which is our autism services court. So a lot of our children that have are on the autism spectrum, as they grow through puberty, they may become more defiant, a little more violent. And so we have a specialty court that provides services and assessments to those families to make sure that they're able to access appropriate services in the community. I am the co-chair of the School Justice Partnership, which helps the school and justice partners come together to try to keep kids in school instead of using exclusionary practices for low-level offenses. We call them focus acts. So that would be like a first-time marijuana offense on a campus, maybe being disrespectful, things that are low-level, and we have helped put school-based services in. I also am part of the Restorative Justice Program through the Nevada Attorney General's led program, and that is trying to connect some of our youth that are committing offenses with their victims to have these restorative circles and decide the outcomes for the perpetrators of those delinquent acts with the assistance of the victims themselves. And we have a court called Dually Involved Youth, and those would be kids that are crossing over from foster care into the juvenile justice system, or kids that are entering the juvenile justice system whose families are rejecting them and then they end up in the foster care system. So we have a team of created experts that handle those types of cases, because what we know is that children in foster care with no family support last longer in our juvenile justice system. They stick to it faster because they lack the family support. These are my 5-year stats. Oh, I can barely read these. Okay, this is, so what I would like you to see here is the increase in the referrals between 2022 and 2023. So referrals would be any case, either arrest or citation, that comes to the juvenile justice system. So what you can see is there's approximately like a 46% increase of charges being referred to the juvenile justice system. The next thing I want you to focus on is the number of petitions that the DA filed. So despite the amount of increase from 5,000 to 9,000, or close to 6,000 to 9,000, we have relatively filed fewer petitions, and that is really the buildup of our diversionary programs in the system. So we're able to divert more children out of the system and file only those that really need to be coming in. You can also see in 2023, we filed 200 petitions to certify youth to the adult system, compared to the 230 in 2022. But what you will note is that we have certified actually almost double the amount. We certified 41% versus 24% in 2022. And when I say certified, that is not, the DA's office doesn't certify them, the court certifies them. The DA's office would just file the motion to seek certification of the child to the adult system for trial. And then the judge would review that. The child has an attorney, there are assessments involved, there's case law that applies. And so the court then ultimately makes a decision of which child would stay in juvenile system and which child would be certified to the adult system. So you can see that increase in 2023. So our top 5 offenses for 2023, and then I tried to compare them for you So violation of probation over the last 3 years has been in our top 1, 2 for the last 3 years of the charges that we file. They usually come, when we file them, they're usually coming with another substantive charge. So it's not just that a probation officer saying the child's not reporting, the child's not doing classes, the child's not, those aren't the ones that are getting filed for the most part, unless it's really been a lot of work on that probation officer to get the child to comply. The charge is coming when they're committing another offense in the community. So if they're on probation and they commit another battery, they're on probation, they steal another car, we're filing both the substantive charge and the violation of probation, which is what's consistently keeping it in the top 1 and 2, in my opinion. Battery, unfortunately, right now, I get my stats from the Juvenile Justice Department. I don't have my own case management system, so I pull from them. And they do not separate felony batteries from misdemeanor batteries. So these could be battery with substantial bodily harm or just a simple battery. But batteries have consistently been in the top 2. They've actually, that should be 2 and 3. They've been in the top 2, top 3 for the last few years. Minor in possession of firearms has been consistently our number 3 for 3 years. That is, it's a huge increase of firearms. With children in our system. Possession of our stolen vehicles in 2023 was in the top 5, where you can see in 2021 it wasn't even in the top 10, and in 2022 it was number 10. And this is based upon this social media post called the Kia Boys, and they're out there showing children how easy it is to steal vehicles with a USB cord, certain Kia models and Hyundai models. And they have been, let me just tell you, we increased 236% in filings in 7 months from January of 2023 to August of 2023. We filed 236% more possession of stolen vehicle cases than we filed in the same time period in 2022, all as a result of that social media post. And those stolen vehicle cases are very dangerous to our community because they're often being used in conjunction with those firearms and the robberies, which you see in number 5 as our top 5 offense. They're stealing the vehicles, they're committing robberies with firearms, and then they're disposing of the stolen vehicle. A lot of kids will come in on a stolen vehicle first time, and then they're released automatically from jail. They don't see a judge. They get a return court date. And by the time they're ready to come back to court, they've stolen 2 or 3 more vehicles. We have children as young as 12 stealing vehicles and wrecking them in communities. And we've had several cases, unfortunately, this last year where we've lost children we've been working with because they're riding in stolen vehicles, high rates of speeds, and killing not only themselves but their passengers. So it's been a very difficult year in 2023 to deal with these stolen vehicles. I know law enforcement would tell you in Henderson, they had an increase of 7 stolen Kias to 113 in 7 months. Metro was going from 260 to 1,258. And these are by juveniles. This doesn't include the ones that are over 18. And North Las Vegas went from 63 to 334 in the same 6-month time period, all from a social media post. The impact of AB 230, I think, is always of interest to this committee. You passed, many of you were a part of it in October of 2021. It went into implementation. Children ages 16 and 17 before AB 230 was passed were excluded from the juvenile justice system and went to the criminal system. Now they stay in the juvenile system for any firearms charges. That would be robbery with use of firearms, mainly discharging of firearms, assaults with deadly weapons being the firearm. So in 2022, after the passage of AB 230, 32 children were able to stay in the juvenile justice system and have a judge decide whether or not they should be certified under a motion to certify. And in 2023, it increased to 36 children were staying in the juvenile justice system with a judge to decide whether or not to certify them to the adult system. So that leaves only children 16 to 17 years of age can be directly filed into the adult system for murder and attempt murder. That is our only direct file charge we have left. And you can see the numbers that we've had, and this is murder and attempt murder. In 2023, we had 16. 2024, we had 3, but as of today, it's actually 4. We had one come in last week. So these are children ages 16 or 17, murder and attempt murder, and automatically sent to the criminal justice system. I'm going to do a little bit on commercially sexually exploited children, child victims of sex trafficking, because we had the passage of AB 412 in 2021 that eliminated the use of secure detention for commercially sexually exploited youth. That bill went into effect for us in July of 2023. So as of July of 2023, any child that is identified in the community by law enforcement as being a child that is commercially sexually exploited is not to be taken to juvenile detention, but is instead is diverted to the Child Welfare Agency under NRS 432C. So from July of 2023 to March of 2024, we've had 105 reports from law enforcement that have identified child sex trafficking victims in the field that have entered into the child welfare system as a 432C child. So what do we do now is the question. When the legislative body said, Ms. Duffy, you can no longer use secured detention when law enforcement finds a child in the street that's a victim of sex trafficking. We panicked because we didn't know where they would go. These are children who run away chronically from their own homes or from foster care. We were left without resources. No additional funding was provided to create the resources to protect these children. Law enforcement was communicating with me on a regular basis. What are we going to do? How are we going to keep these kids safe? And we're advocates. We didn't want to lock them up, but we needed resources to do something because we know that if we do not secure them, if we do not get them to an appropriate place, they're just going to continue the cycle until they stop, and hopefully not until we're no longer able to find them. So what did we do? Now we have a system in place that we have created, and I know you're going to hear from some of my great system partners later in the agenda. But now when law enforcement makes contact with a child that he or she has reason to believe is a CSEC victim, they contact local advocates, and local advocates will meet at the scene to offer resources to that child and their family. Law enforcement will also contact the parent or guardian of the child if the child is a Nevada child. Law enforcement informs the parent or guardian that a report is being made to the Child Welfare Agency and that a member of the Child Welfare Agency will be reaching out to the family to provide services, not to remove the child, but to provide services. And then the child is released to the parent or guardian. What if they don't have a parent or guardian to release to? I know that's your next question, so I'm going to tell you something I am very, very proud of for Clark County. Clark County used forfeiture funds, which is a very little known tucked away statute in NRS 201-351 sub 4. This is a statute that is a district attorney's office has an account with the county treasurer where funds that are forfeited after the prosecution of the trafficker are deposited. So after a trafficker is prosecuted, if any of the proceeds of this are available to liquidate as a forfeiture, then after other things are paid, the district attorney's office gets the rest in a fund kept by a county treasurer. And those funds by statute can only be used for the prevention of child sex trafficking or for services for victims. And so when I located this statute, I called around a lot and I said, how much money is in this fund? And the Attorney General's office had just done a prosecution of a massage parlor in town that had several homes and businesses that were able to be liquidated. And there was a few $1 million in this account that was just sitting there. And so I went to DA Wolfson and said, may I use those funds to create housing for our victims? And he said, yes, yes, yes. Put me in charge of the funding. I connected with the Department of Family Services, who now is under NRS 432C, in charge of the children that we cannot use secure detention for. And we have opened 3 homes in Clark County as safe houses for these victims. 2 are run by Eagle Quest Foster Care Agency, and 1 is out in St. Jude's Ranch. It's a total of 23 beds. And as of the time I created the slideshow, there were 15 beds in use. They have beds for both boys and girls. and emergency beds if needed, meaning short-term beds. They're really designed to be long-term programmatic beds, but if in the middle of the night we don't have a parent to release to, we have short-term emergency beds as well. But it is not sustainable with forfeiture funds. So I do need to let you all know this was a great thing to do, but not sustainable. So moving forward, what does Clark County see as a priority? We need a commitment to sustain the funding to provide safe houses for victims. I will tell you that it cost from the forfeiture funds $1.492 million for 1 year to run those homes. That's with services and shelter for our victims. The great thing I love to say is that we are using the monies from the people that traffic these children to house these children and provide them with services. That is a great thing that Clark County is doing right now. But if there's no forfeiture money, we cannot fund the houses. So it would be, now I'm able to come in when people say, how much would it cost to give a house? I can say it costs us $1.492 million a year. We need a blended sentencing model that includes developmentally appropriate program for our violent offenders, and listening to public comment. And, you know, everybody knows, everybody hears it. I believe it. Our children aren't fully developed in their brains until they're 25 at least. I have a 16-year-old, and I see it every day, a 16-year-old boy. So we need something that's more appropriate. And I'm hoping that my message is being heard, and I've talked to two very, very amazing senators to hopefully come to an agreement to bring some legislation forward this session that will expand our youthful offender program in the Department of Corrections. If you haven't had a chance to see it in the Northern Nevada Correctional Facility, I suggest you go and tour it before the session starts. It will give you a better understanding of how youthful offenders, those under the age of 18, are treated when they are committing these murders and attempt murders or multiple armed robberies, and they're sent to the adult system. It is the best facility I have seen. I toured it myself in October of 2023. It opened in May of 2023, and it is the best that I have seen that we can do for our children. And I think there's room for expansion to start including upper ages for that, but I will have to continue those discussions with Department of Corrections. And we need improved mental health services in our schools and our community so that we can continue to divert children away from the juvenile justice system. Our mental health systems are broken. Our juvenile detention center is backed up with kids who really need mental health treatment and not locked up. Our schools are excluding kids from education because it's necessary, because of the way they are behaving. But with the appropriate mental health services in place, I believe that we could get more inclusion of schools and children. So that's my presentation, and I'll kick it up to Shelley, and then we'll be happy to take questions if you have any.
Good morning, Chair Miller and members of the committee. My name is Shelley Scott, S-H-E-L-L-Y, Scott, S-C-O-T-T. I am the Chief Deputy District Attorney for the Juvenile Division. I concentrate only on juvenile delinquency. There is a separate chief in Washoe County that handles dependency. So for my comments today, they will be addressing only the juvenile justice delinquency programs in Washoe County. As ADA Duffy has indicated, we have our programming, excuse me. The history of juvenile justice, it came about because our system recognized the need, and I apologize, recognized the need to incorporate rehabilitative services in dealing with juvenile offenders. That the program initially, back in the 20s, in the 1800s, was punitive. They didn't know how to deal with juveniles. We were just small adults or young adults. As time progressed, as education progressed, as information on child brain development progressed, the juvenile justice system was created to identify and treat separately juvenile offenders from adult offenders. So by 1899, the first juvenile court was established, and by 1925, all but 25 jurisdictions had a juvenile court. In the 60s, due process came to juvenile justice in In re Galt. That is where our juvenile justice system gets its constitutional protections and due process for youth. Juvenile justice is a statutorily created system, so it operates only within the rules and statutes and legislation that you legislators provide for us. With that, we began a system of reform to move kids out of detention facilities into services on a quicker basis. We now use a balanced approach that came to us that deals with community protection, competency development, skills development, and yet gives the juvenile, holds them accountable in some manner to, thank you, some manner to address the underlying behaviors and in a teaching format. Juvenile justice alternatives to detention was implemented in Washoe County in 2004. I have been with the department since about early 2002. So I was here to be able to see the changes that were implemented with the goal of reducing time of youth in detention facilities, getting them access to services in their homes or in an alternative placement instead of a locked up facility. What that did was, within the JDA alternatives, they identified what can we do, how can we keep the community safe under this balanced approach, but keep the kids out of detention and give them the services they need to not reoffend. We can always straight release them from detention because there is no bail system in the juvenile system. But most often we use conditional releases where the court can intervene initially to order evaluations for substance, for mental health. No contact orders are imposed on a limited basis to keep perpetrators away from victims. We can monitor them with a house arrest or electronic monitoring so that probation services are overseeing the youth. Programming was put in place with evening reporting programs to fill that time gap between when school let out and when many parents returned home from work. We found that several hours between 2 and 6 o'clock, the kids were left unattended. The evening reporting programming gave them a place to be with supervision, with education, with pro-social activities. So you've seen this overview of the process. As Chief Duffy indicates, we get the kids into the system by arrest, a citation, or referral. And there's multiple points during this system where they can be diverted away from formal court process. For misdemeanors, many are diverted before they even come to the district attorney's office. Juvenile services, juvenile probation is the top of the funnel and guides that system toward diversion toward my office. For misdemeanors, all can be handled legally by juvenile probation. After their assessment, some misdemeanors will be referred to my office for other reasons than the crime, usually because of family resources, ongoing family issues, ongoing misdemeanor offense where informal has not been successful in rehabilitating the child. If the case comes to my office and is referred by my deputy district attorneys, they then have the opportunity to decide whether to file charges or to refer back to juvenile services and divert back out of the juvenile justice system. What happens is this funnel effect. The number of cases that come into this system start getting weeded off so that Services are being provided to youth. Interventions are taking at the lowest level. And as we work toward the bottom of the funnel, only then are we seeing placements out of the family home to boot camps such as China Spring and Aurora Pine, such as correctional placements with the state at Caliente, Elko, and Summit View. And then ultimately, the very few that are diverted completely out of the juvenile justice system and taken to adult certification. The detention criteria that the court must use to determine whether or not to issue or to hold a child is likely to commit an offense, threat of flight, fugitive from another jurisdiction, warrants, or a violation of a court order. So if a child does not meet these criteria, they will be released home with services. We expedite the cases as much as possible in the juvenile justice system, even for those that remain detained. Our charging document must be filed within 4 days if a youth is detained, and his trial must occur unless there is a waiver, within 60 days. So we recognize the need to move the children from the detention facility into their ultimate disposition at a rather rapid rate. The dispositional outcomes are what are referred to in the adult court as sentences. It is noted that unlike adult court, there are no mandatory incarcerations for juveniles that have been adjudicated. There are mandatory community service hours, there are mandatory evaluations, there are some mandatory schooling, but there is no mandatory incarceration. So that's one thing that we really diverge from the criminal system in that respect, in trying to put the services in place to correct the underlying issues. Washoe County is a much, much smaller division than we have in Clark County. My partner, or Ms. Duffy down in Clark County, has a population of several million compared to several 100,000 in Washoe County. And the rurals speak even less. So our resources are considerably less, our staffing is considerably less, but we're handling the same type of children just on a much smaller basis. I have 4 attorneys, myself, and 3 deputy district attorneys, 2 legal secretaries, and an office assistant to help process the referrals as they come in. We do not have any assigned advocates or DA investigators that are specific to the juvenile division. We are in a pool, and whatever investigator or advocate is available, we will have petitioned it basically to have it assigned. All of our sex offense cases receive an advocate. All of our serious violent offenses where substantial bodily harm has been occurred will automatically get an advocate assigned at the front end, but the advocates share responsibility with the regular criminal teams. In Washoe County, we saw a drop in referrals and charges submitted to our office during the 2022, the COVID effect, as everything has been termed. We are now back up to and even exceeding the number of charges and referrals received in my office pre-2019 indications. We have almost 2,800 charges that get referred, and it's important to note that these charges come in multiple on a referral. Back down here, the referrals in green indicate that we have close to 1,400 referrals from juvenile services and youth parole. Those referrals can include multiple reports from multiple agencies, because juvenile services especially tries to work with the youth before sending the case to us. So the referrals can oftentimes have cases from Sparks Police Department, Washoe County Police Department, and Reno that are all combined on one referral. And of the referrals, we know issued close to 400, the remaining were filed. This is a breakdown of the severity of the charges. whether we receive felony misdemeanors or gross misdemeanors. This year, of our total referrals in the green column, the referrals that were other than felony were just over 900, and then the felony offenses were just about 400 to 500. What this means is when it got put into the juvenile court system, those that we actually filed charges on, the juvenile court ran a 12-month rolling calendar of how many cases are submitted each month to the Juvenile Delinquency Department for filing cases. And these were the raw numbers, which totaled to 929 cases in the last rolling 12 months were actually issued and went before the Juvenile Justice Court in Washoe County. Our top 10 charges, here you see, just as Chief Duffy, or ADA Duffy indicated, violation of probation or parole is our highest offense. And like Clark County, that means they're often incorporated with other delinquent offenses that have come before the courts. What we see in Washoe County is, without the resources of the harbor, was a significant increase in vape cases, primarily at the school. That accounts for 377 charges in 2023. That being such a high number, Washoe County Juvenile Services and the District Attorney's Office worked together to create a process of a diversion, which I will touch on momentarily. We note that the battery charges and the firearm charges are part of our top offenses, as they are in Clark County. The firearm cases, Washoe County gang unit removed 100 firearms from our gang offenders this year, which was great to get the guns off the street. But we've got kids that are holding, kids that are using the firearms and creating many of the offenses that we see in our juvenile justice system. When we addressed the cannabis, the concentrated cannabis or the vapes, what we did was create a memorandum of understanding. NRS 62C200 allows juvenile services to handle gross misdemeanors and felonies informally with the consent of the Juvenile District Attorney's Office. What we did in order to divert the kids out of the juvenile justice system and get service immediately in place was create a memorandum of understanding that when these kids came in that were assessed by probation as either first-time or low-risk kids, and they were determined to not have any prior felonies, gross misdemeanor offenses, and or crimes of violence, they were given immediate access to case management services, rehabilitative programs to address their substance use, and accountability in the term of programming and community service without any formal court intervention. This year, in the first quarter of 2024, after this program went into effect, we have received at Washoe County Juvenile Services 56 cases of concentrated cannabis vape pens. Of those, 51 qualified for the Memorandum of Understanding and were immediately diverted out of the delinquency system. So the program seems to be working. We have monthly checks to see if the kids are completing their informal sanctions, and at approximately 120 days, if sanctions haven't been completed, programming, we are alerted and make a decision on whether or not to file charges or to increase their time and ability to finish their informal supervision. It seems to have an immediate and a positive effect instead of waiting for court dates to come up, which delays things several months. Kids whose immediate consequences and immediate services are important are now getting those instead of waiting, and that cause and effect is being addressed immediately instead of coming to court. The effects of our recent legislative changes, I'm touching on 3 different issues: the certification or transfer to adult court, record sealing, and the terms of probation. As ADA Duffy indicated, certification and AB 230 were recent changes that have had very large effects on how we do business as far as certifying or automatically direct filing cases into the adult system for kids under the age of 18. Because now only murder and attempted murder at age over 16 and older can occur. We have not seen as significant an impact in Washoe County as in Clark County. Our numbers are much different. The impact of AB 230 has, last year, we filed only 5 motions for certification. They were for battery with a deadly weapon causing substantial bodily harm on 2 of them. Murder and a challenge to fight was 1, and battery with a deadly weapon. All serious violent offenses where the offenses occurred. The kids were 17 except for the murder and challenge to fight. That was a 14-year-old female who stabbed her rival to death. And because she was under the age of 16, it started in the juvenile justice system. Of the 5 that were filed last year, 1 was withdrawn, 1 was stipulated, and 3 were moved to the adult system. 3 of them, those 3 that were moved to the adult system that would previously have been automatic, were now motioned, and the judge made the determination on 3 of those cases to go ahead and certify them. Traditionally, our numbers have run between 5 and 8 certifications a year, and I've put the stats for the last 4 years here for you to look at. 2019 pre-COVID was the largest we'd had in quite a while. We had 11 that were filed, 9 where the kids stipulated, 1 that went to a hearing and the court granted the motion, 1 that we withdrew, and 1 of those cases that were processed in 2019, only 1 would have fallen or did fall under the AB 230 numbers. So we have been affected, but not tremendously. It looks like most of our offenders and the people that we are moving to certify are between 16 and 17 years of age. Automatic sealing of records was modified from age 21 to 18. It has created some conflict with adult sentencing and PSIs, which are pre-sentence investigations, where parole and probation does a background investigation onto the youthful offenders. It allows for records for youth that are up to age 21 to include their juvenile history in the PSI. With 18 being the time the juvenile records are now being sealed, the PSIs are not being able to capture the full information. The courts in the adult system are not having the full information, which may or may not have been the intent of the legislation. We have not had a juvenile petition to have their misdemeanor record expunged since the operation of this. We have only had 1 that is pending a petition to have their records sealed that does not fall under this automatic sealing statute. The other unintended consequence is making it very difficult to pull good statistical information for you as the legislators on how the statutes have been operating in the public, because we're losing a few years. We've also had children that are now age 21 that need some of their information on their prior offenses and have not been able to get it because their records have been sealed. So I think it's something we'll probably need to take a look at in the future. it's just something at this point that we've noted, and this went into effect, as I indicate, the end of December of 2021. The juvenile probation terms were limited. Period of probation was imposed with a maximum of 18 months. We are just now reaching that target date from last legislative session, so I think it's too early to tell how that's going to unfold. The legislation was had some points that were unclear on how it applied to reoffenders, violations of probation, etc. It may need to have some clarifications, modifications to the language as far as terms of probation and how it's applicable, because different jurisdictions seem to apply it differently at this point. And lastly, moving forward, Ms. ADA Duffy and myself have some of the same concerns. The juvenile justice system in Washoe County's mental health services are sorely limited. We have a total of 4 facilities that are available for our children here: Reno Behavioral Center, the Cy Mental Health, Willow Springs, and the last one escapes me, I'm sorry. Those facilities are overrun. We are having a difficult time getting placement, as most of our kids in detention that are pending residential placements where their mental health needs are not being met in the community, that they need residential and non-intensive or partial hospitalization, are waiting. That's where a lot of our bed dates are coming from in the detention facilities. Competency development programs, we have a lack of providers who are willing to work with the juvenile justice system to create to undergo forensic competency evaluations of our youth. That is, again, creating delays because one evaluator or 2 evaluators trying to address the issue of competency in our courts before we can move forward has caused a delay in moving kids out of the system, and even when they're out of custody through the system. Lastly, the blended sentencing model. The state would be encouraged by increasing juvenile justice jurisdiction such that we touch those youthful offenders 18 to 25 who have entered the correctional system. The Northern Nevada Correctional Center is now the local housing for youthful offenders. I was there last month, and I was very pleasantly surprised at how the facility is being run, the care that the staff have with the juveniles. They have not, as of last month, had to use any use of force on the juveniles in the system. The juveniles have a wide area of recreation, but they don't have the money, they don't have the funding for the services and programming that is so important. And the facilities are old and need to be updated, but the programming is key. The education that these kids were being provided is the one area where I think our correctional system was doing very well with our youthful offenders. I thank you, Madam Chair and committee members. This concludes my presentation.
Thank you, Ms. Scott. Members, do we have any questions?
Madam Chair,
I do not see any here in Las. Is that you, Assemblyman Gray?
Yes, I'm sorry. I thought you were asking the entire body. I didn't know you were going to Vegas first. I do have a quick question regarding the safe houses.
Okay, proceed.
Thank you, ma'am. With the safe houses, are you guys experiencing, because I noticed it was a very low utilization compared to the beds available, and not very low, but I mean low. Are you guys experiencing a lot of walkaways or runaways? I mean, these kids are, we need to get them the help. And I definitely don't like the idea of locking them in facilities, but we need to get them the help they need. I'm just wondering how you guys are enticing them to stay, or what actually keeps them there, and if they're actually staying.
Assemblyman Gray, thank you for the question. This is Bridget Duffy for the record. I couldn't give you a statistic. I can give you what I've learned from touring the housing facility and talking with the providers. Of course, we get children that leave. They leave. What is a great thing that happens is they stay connected to the staff. So when asked how we keep them from running, it's the connection they have with the staff. So the staff that work in these houses, and it's 24/7 staff run, they tell us, myself and my partners with other law enforcement agencies like our vice unit, that they make contact while they're out on the run and say, I'm okay, and then they will come back. So the vacancies in the beds right now has more to do with the staffing, needing to get a few staff into one of the homes so that we have the beds that are vacant, but we need some staffing ratios for the children that are going into the home. But yes, they leave. They're allowed to leave. But the positive thing is that they've connected to staff members enough to want to come back, and when they're ready to come back. And the door is always opened.
That's really good to hear the connections are being made. That foundation is very important. And the other question is, who did we talk to about the tour you had mentioned earlier of the juvenile offender program or the facility up here in Northern Nevada?
Bridget Duffy, for the record. Again, thank you for the question. I reached out to the Division of Child and Family Services, one of their leads, and they helped set it up with the warden and the assistant warden for me to visit. Chief Scott, I'm not sure how you set yours up. Maybe that would be helpful to know as well.
I have the contact information with the assistant warden. He was the one that coordinated the tour of the facility, and I will be happy to provide his email to the committee so that he can work on coordinating a tour for Assembly for anyone interested from the Assembly Interim Committee. Thank you.
Thank you so much for the answer. Madam Chair, that's all I have. Thank you.
Thank you. Members, any additional questions? Not seeing any, I will go ahead and close agenda item 12. Thank you for your presentation. We will move to our next agenda item, which is agenda item 4, a presentation from the Office of the Attorney General on domestic violence, human trafficking, and sexual assault in Nevada. Our presenter is Nicole Riley, the Ombudsman for Domestic Violence, Sexual Assault, and Human Trafficking with the State of Nevada Office of the Attorney General. And so we'll give you a few moments to get settled in and have your PowerPoint presentation adjusted for us. And so just take a few moments, and whenever you're ready, please proceed. Sorry. Do we have someone that could... Okay, thank you. Someone's coming. Oh, okay, so we can view it on, yes, it's on Nellis, everyone. All right.
Okay, good morning, Chair and Vice Chair and committee members. My name is Nicole Riley, as stated, Nicolereill. And again, I'm the Ombudsman for Domestic Violence, Sexual Assault, and Human Trafficking at the Attorney General's Office, and I'm here to update everyone on what's happening with the Committee of on Domestic Violence that the Attorney General's Office facilitates. I first put on what the mission of the Committee on Domestic Violence is, and it's to encourage the elimination of domestic violence and to help break the cycle of violence in Nevada. And then the purpose of the Committee on Domestic Violence, is to prevent and eliminate domestic violence through increased awareness of the existence and unacceptability of domestic violence in our state, review the death of a victim of domestic violence, and recommend legislation. The membership is made up of a variety of professionals, which include law enforcement, judiciary, prosecution, Division of Public and Behavioral Health, victim services, a batterer's treatment provider, a mental health care provider, and domestic violence survivors. One additional member that we are so pleased to have is Dr. Tracy Herrig. She's a nurse practitioner who previously worked in the trauma unit and another place is an OBGYN office, and she's been really integral in providing training to the nursing school up north and creating domestic violence protocols for the medical community to go ahead and do assessments or be aware of red flags in any sort of medical setting. So we're thrilled to have her. She's a huge benefit. The Committee on Domestic Violence meets at least 3 times each calendar year. One of those meetings is located in a rural district, and so the entire committee travels to that district, and we invite as many stakeholders from that community to participate in the meeting as well. And we also have created 2 subcommittees. One of them is a rotating one. So once we get completed with that action plan or find that we're kind of at a dead end with that action plan, for the time being, we'll sunset that committee and then we'll recreate other committees based on what has been identified as gaps and challenges. So at this time, we've got the data subcommittee, which is identifying data points across the system needed to clearly understand the full severity of domestic violence and sexual assault in Nevada. A good example of this, where we have a huge disparity and we really need to understand it, is when there is a domestic violence homicide, the perpetrator is getting charged with open murder and there's no domestic violence flag. We lose the domestic violence flag. So we don't have a full understanding of how many domestic violence homicides have actually occurred in the state of Nevada. And the numbers that we do have on those is fairly high, and we can only imagine how much higher it would be if we had that domestic violence designation. So we are working on finding a way where is the best place. The prosecutor's office, I'm thinking, is the best place, but we're going to have meetings with all of these stakeholders to find out where we need to have even a checkbox that says this is domestic violence related, and then where we are going to be housing that data so that it's accessible to the public on, for example, the crime stats website or something like that, that makes it more clear on what's happening in the state. Another data point is on TPOs, how many were submitted, how many were rejected, and why they were rejected. And if it was because of not completing the application correctly the first time around, are they being provided with that information and then resubmitting the TPOs, or are they just giving up on the system and not even bothering doing that? We have created an action plan that is very detailed so far. We're still working on it. It's a draft action plan that is very detailed on what data is really pertinent to domestic violence and sexual assault and where that data would be coming from. So we've looked at the courts, the judiciary, law enforcement, prosecution, parole, Department of Child and Family Services. We also lose that. We don't have a designation because they're dealing with the children, abuse and neglect. But we're going to be asking if they can now start tracking cases where they identified domestic violence in those as well. So those are big gaps. Those are big numbers that we're actually missing and would help really clarify what is happening in the state for domestic violence. And it would also really help the service providers in attaining funding for their services, because our numbers would be so exponentially much higher than they are now. We typically, just on the numbers that we have, which is the cases that were identified, typically in the media would identify them as domestic violence homicides. So that's the only place we're getting data from. One of the things is we've rated consistently in the top 10 of severity of domestic violence in the nation. We have been number 2, 3, 5, and I think this year we're at number 7. But again, we don't have the full picture of what's happening, and that's what we're trying to put together so that it can be provided and we can increase funding to our service providers in the state. The next committee, which is a permanent standing committee, is the statewide fatality review team. The purpose is to gather information about fatalities related to domestic violence, and then it's a multidisciplinary team that are members of the full committee that have volunteered and want to be a part of the fatality review. In this process, we identify opportunities for improvement and make recommendations for prevention of future deaths related to domestic violence. So we take a specific case and get all of the discovery, comb through it, look for any places where intervention was missed. We've also had a case where luckily we had a bunch of data on there from the medical side, and so we were able to identify all of the intersections where she crossed with mental health providers and emergency rooms. She had a lot of visits to emergency rooms, and no one ever tagged her as being a victim of domestic violence as well as being trafficked by her significant other. And in the end, he took her out to the desert and set her on fire next to the road to make a point. So that was a really very sad case. There was an infant left behind without a mother, and then a father who was eventually caught and incarcerated. Let's see. Oh, I did have, if I could quickly read, I just received this email from District Attorney Tyler Ingram in Elko County. He said, the only reason I'm bringing this to your attention is to highlight an issue that we constantly have to face, and perhaps it will start a discussion in our committee, the Committee on Domestic Violence, about the truth in sentencing in Nevada, especially as it relates to the actual prison time that abusers do when they are convicted of felony domestic violence, recognizing that the guy below was not imprisoned for domestic violence. This certain individual was sentenced on December 20th, 2018 for resisting a public officer with the use of a firearm, eluding a police officer in a manner posing danger to a person, and possessing a firearm for a prohibited person. He was sentenced to an aggregated 48 to 120 months, which is 4 to 10 years. With his credit for time served in jail, he began his prison sentence on July 28th, 2021. He was released from prison in 2022. He was supervised on parole for less than 1 year and was honorably discharged. So when a judge says the maximum sentence is 10 years, what that actually means in Nevada, in way too many cases, is that you are free from prison and free from supervision in less than half of the time actually sentenced to. Now this guy is back on the streets of Elko, live streaming videos of our CADV Harbor House, which is the confidential, secure shelter in Elko, which is garnering comments such as, and he's posting these on social media, now I know where those unfavorable word, starts with a B, are so now I know where they are, so I can go beat them again. So now the security and confidentiality of the shelter in Elko is no longer secure and safe and has been completely compromised. Law enforcement is very aware of the situation and they're doing what they can, but this is a disturbing situation that has the potential to become dangerous. Best case scenario would be that this guy would still be in prison for shooting at cops. At minimum, this guy would still be supervised on parole so that the state would at least have an easier remedy to address the situation. Of course, there are examples which are far more egregious than this, but the connection to CADV and the shelter in this situation puts this squarely in our wheelhouse as a statewide group. So that concludes my presentation with a couple of emphasis points from DA Tyler Ingram as well, and I would open it up to any questions if you have any.
Thank you. Members, any questions? I don't see any here in Las Vegas or online or in Carson.
Okay,
So
great.
with that, thank you for your presentation.
Thank you so
I will go ahead and close agenda item 4, and our next agenda item 5 is a presentation from advocacy organizations on the services available for victims of sexual assault, domestic violence, and human trafficking in Nevada. At the table, we have a few different presenters. We have Ms. Riley again, the Ombudsman for Domestic Violence, Sexual Assault, and Human Trafficking from the State of Nevada Office of Attorney General. We have Ms. Serena Evans, the Policy Director for Nevada Coalition to End Domestic Violence. We have Liz Ortenberger, the Chief Executive Officer from Safe Nest. And we have Lauren Bottell, the co-founder of Nevada Policy Council on Human Trafficking. Just one note for the materials from Ms. Bottell, those were just submitted this morning, so members, you were emailed those revised materials if you haven't had a chance to view them yet. And so with that, again, we only have 3 chairs, but we're going to let you all alternate and rotate through. Again, we're asking that everyone keep their presentation as concise as possible because we do have a robust agenda. And with that, we are ready for whenever you are ready to proceed.
Good morning. My name is Elizabeth Abdur-Rahim, ELIZABETH, ABDUR-RAHEEM. I am the Executive Director of the Nevada Coalition to End Domestic and Sexual Violence. I want to thank Chair Miller and the entire committee for taking time for these most important issues that are facing the victim survivors across Nevada. Today, and especially in April, as we come to the end of recognizing Sexual Assault Awareness Month, and all of the amazing work that has been done in Nevada but is yet to be done in Nevada as well. So the coalition, as we call ourselves NCEDSV, we have been supporting the Frontlines domestic violence and sexual assault agencies in Nevada since 1980. We are one of the 56 statewide coalitions around the country that support the Frontlines work that happens every day, keeping people alive and safe. So we are a statewide coalition. We have members of direct service providers as well as collaborators, other stakeholders, individual members, including victim survivors. And we work for the prevention and the elimination of power-based violence across our state. Our coalition has 3 main pillars of work that we do. The first one is support for all of our Frontlines agencies. That includes technical assistance, to help with program development, building up our best practices across the state, making sure that we are really providing the best, most current, most evidence-based services to everybody in the state. We also fund interpretation services for our direct service programs, and we call together the Weaving Communities group, which supports our tribal victim services agencies and the advocates who are working out in some of the most remote areas and really challenging communities and making sure that they have support that is culturally appropriate. We also have a strong training department. We provide training not only to advocates, but also to community members and community partners. And then we have our strong advocacy department, our policy department. This does the systemic advocacy that comes here and meets with you, that goes through all of our legislative sessions, really making sure that Nevada is legislatively and politically becoming a safer place every day for victim survivors here. Then we do a small amount of direct service. We provide financial support directly to victim survivors. One way is in microloans so that we are rebuilding people's credit and making sure that the financial abuse that happened, that we can start to try to reverse that and people will be better able to move forward. And the other is our Jan Evans Fund, which is direct grants, up to $500 to help people make some of those real quick financial gains that they need to move out of the situation that they're currently in. So this is a map of the domestic violence and sexual assault service providers across Nevada. 14 of them are currently full program members of the coalition. We also have 21 affiliate members. All of the program members, their main mission is direct violence and sexual assault. Many of our affiliate members, that also may be their main mission, or they intersect with domestic violence and sexual assault. So you can see that we cover the whole state, but then, as we know, Nevada with a frontier state, people often do have to still travel a long way to get services, and our programs are always working at how we can best collaborate and how we can best coordinate to make sure that wherever a survivor is, that they can get the support and the resources they need. So we have heard so many times about the statistics here in Nevada and the grave statistics. I know that you're all aware of them, but we will highlight them again. We currently rank 5th in the country for rapes per capita at 67 per 100,000 residents. We are 2nd in the country currently for rates of domestic violence, with 44% of women and 33% of men experiencing intimate partner violence in their lifetime. Recently, the Violence Policy Center put out their most recent women being killed by men report. And for the last 23 of 25 years, Nevada continues to be on the top 10 list. So we know that this is, it is home, it is in Nevada, and we have to keep talking about it. We have to make sure that people are aware, right? The first part in a victim coming forward is knowing that people will believe them. And if we are too afraid to talk about this, if this is too much of a taboo, and if it lives too much in the shadows in our communities and in our law centers and all of those places, victims will not feel safe to come forward. So if we look at our crime statistics, we have seen this, we've talked about it other times. In 2023, law enforcement across the state responded to over 28,000 domestic violence reports, and they responded to over 1,600 rape reports. We know that sexual assault continues to be the least reported crime, and we estimate that this is only about 1/3 of people who have actually experienced rape. We also know that the definition of rape is very, very limited. It is not the definition of sexual assault. It is not the definition of sexual violence. So when we look at this number, we have to understand the vast underrepresentation of actual sexual violence that is occurring in our state. But what's happening? We have good news about some things that are happening. Our direct service providers work incredibly hard, 24 hours a day, 7 days a week, 365 days a year, right? Nicole just talked to us about what has happened in Elko, where their services and their confidentiality is being compromised every day, and yet those advocates go to work every day. And I think that's an important thing for us to remember, that it is not only our victim survivors who are in danger, it is also the people who choose to do this work who get put in danger, and yet they show up every single day for their community. The National Network to End Domestic Violence does the domestic violence count every year, and it is a point-in-time count that says who's really being served in one day. It's a snapshot. So most recently, it was done on September 6th of last year. In that 24-hour period, our providers reported that they saw 692 victims. That was a 21% increase from the year before. They answered 292 hotline calls. That was a 150% increase from the year before. It is important that we recognize that a 100% and 50% increase does not necessarily mean that domestic violence went up 150%. It means that people were more willing to reach out for help. It means that we were better able to connect with them. And we need to know that when these numbers go up, it does not mean that our providers are not doing their job. It actually means they have done their job so much better that people are trusting them in their most vulnerable moments. Still, our providers saw 40 people that they could not meet their needs of that day, and 85% of those needs were for housing. We know that when people do not have safe places to go, they will not leave or they will continue to return. When the choice is to live on the street or to live with your abuser, many people will choose to live with their abusers. So we also know that housing is a violence prevention tool that we have to pay attention to, along with economic justice and poverty. All of these are violence prevention tools. In 2022, our program members served over 46,000 individuals in that year. And now I am going to turn it over to our Policy Director, Serena Evans.
Good morning, Chair, members of the committee. Serena Evans, SERENA-EVANS, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. I know later on in the agenda, the AOC is going to present on protection orders, so I don't want to spend too much time looking at these numbers, but I do just want to highlight that we are hearing from our direct service providers and victim survivors daily at the astronomical rate of denials of protection orders. We are hearing that victim survivors, when they're going forward for an extended protection order hearing, judges are flat out saying, I don't believe you, you're lying. We are also seeing issues with service. So since COVID, a lot of the protection order hearings have moved to Zoom and have stayed on Zoom, which is great for many purposes, but courts are not able to serve the adverse party directly there. They're also not clearly communicating with victim survivors that the protection order has not been served. So victim survivors are leaving their protection order hearings thinking a protection order is in place when in fact it has not been served, is not in place, and then a lot of times they expire before they actually get served to the adverse party. Another issue we have been hearing is that in extended protection order hearings, judges as well as defense attorneys are often doing criminal questioning of the victim survivor. And so there needs to be some clear guidelines of what can be asked and not asked during a civil protection order hearing, because the lines seem to be getting a little blurred there. And just, we tell survivors to seek a protection order for safety. We often, plan that into part of their safety plan. And so when we cannot account on a protection order, victim survivors may be less likely to leave, or they may have a false sense of safety. And so this is an issue that we really need to look at as a state of how can we resolve these issues. Next, I want to talk about the 2023 Domestic Violence Homicide Report. So this is the first year that NCE-DSV has put out the report in this way. We used to do a report, I think the last report we did was in 2017. It was done vastly different. So this is the first year in which we collected instances of domestic violence homicides through public records, as well as the gun violence archive. So public records, think like Google alerts. So anytime there's a news report stating that there was a domestic violence homicide, we counted it. So in 2023, there was a total of 72 lives lost due to domestic violence homicide, resulting from 50 incidences. So of those incidences, 16 were murder-suicides. What we're seeing across the state is that domestic violence does not discriminate. Age, gender, there were just reading these stories day in and day out was just gut-wrenching. Just to put this in context, so Nevada has roughly about 1/4 of the population of Ohio, and in 2023 we had comparable rates of domestic violence homicides. So the statistic that we rank second in the nation for domestic violence is, this is how we can quantify it. So we are going to continue this report annually. We're looking to build out partnerships with law enforcement, the Attorney General's office, to make sure we're really getting all of the data. We know that we're probably missing a handful of domestic violence homicides, and as Nicole spoke to earlier, a lot of times they don't label it a domestic violence homicide. So we're trying to figure out how can we collect that data to really get a full picture. SANE exams in Nevada, I know I've sat before you all and talked about this issue. So there's currently only 6 locations in Nevada to receive a SANE forensic medical exam. However, in Elko, we did just launch a mobile SANE unit. So Nora Lusk with the Nevada Institute for Forensic Nursing is doing amazing work in the rules. She is taking a mobile home to go and meet victim survivors where they're at to provide a forensic medical exam. But, depending on their location, some victim survivors are still driving upwards of 4+ hours to receive a SANE exam. I know here in Clark County, there's only one location and one nurse that is providing these SANE exams. So last legislative session, we did pass, I think it was AB 276, that allowed for SANE to be conducted via telehealth. However, it was an unfunded mandate, and so we haven't really seen that come to fruition yet because we are lacking the technology across the state. To wrap things up, I just want to talk about the most pressing challenges. I know that you all you all are not a funding committee, but I would be remiss if I didn't just state that funding is crucial in terms of prevention and intervention services. We are seeing funding decrease everywhere, and our programs are doing the best that they can to serve victim survivors, but we know that they are not meeting the need and the capacity. Scarcity of services, so our rules in particular, we have amazing service providers that will, do advocacy. They will go out to them in the rules as well as through virtual capacity. But there is not enough services. And in terms of services and resources, we also know, going back to housing, fair wages, there are not enough supports to allow victim survivors to leave these horrific situations. Distrust in the system, so victim survivors don't have a lot of trust with the criminal justice system. They, go to get a protection order, it gets denied, they get called a liar, they are not likely to return, they're not likely to call law enforcement again. So we need to figure out how do we build trust in our system to keep folks safe. Protection order denials, I think, that speaks for itself, as well as community education and prevention. We tend to be very reactive instead of proactive when it comes to domestic and sexual violence, and I think there's a great opportunity to do, statewide prevention programming, statewide prevention education, and we're really missing an opportunity by not doing that. So with that, we will open it up to any questions that you may have.
Members, any questions? Yeah. Go ahead. Go.
Thank you so much for your presentation. I have a couple of questions. The first one, I want to go to your comments about the definitions of rape and our data collection process. And I was hoping you could just clarify a little bit for us the differences between the statistics that we're able to gather versus the statistics that we're not able to gather.
Thank you, Senator Serena Evans, for the record. Yeah, so NRS definition of rape is penetration, whether that be, with a penis, a finger, anything of that sort. But we know that that does not include all instances of sexual assault. So it doesn't, cover groping, voyeurism, so many other things, and sexual assault is so personal to each victim survivor, so it's really hard to state exactly. But the numbers that we have in the state are collected by law enforcement, and law enforcement only reports on rape and what meets the definition of rape. There is, I just lost my train of thought. I'm so sorry. That 4 a.m. flight is hitting me. The other instances of unwanted touching, there is an NRS statute for it, and I can't remember it off the top of my head, but it is not collected in data by law enforcement of when that is reported on.
Okay, so what we're collecting is what is defined in the Nevada revised statutes as sexual assault, but you're saying that there are other things that you would define as sexual assault that aren't being included. And you did mention groping and touching, which I think would be, probably instances of gross lewdness. And is there a reason that we can't gather those statistics and report them along with the legal sexual assault statistics to get to a more comprehensive, sexual violence statistic?
Serena Evans, for the record. Yes, so that is correct. And I think that we would have to work with law enforcement on just their collection process. It's probably something that is feasible, but just would require a little bit more coordination and collaboration, because we get these numbers from the Nevada Crime Statistics webpage. So if we can get law enforcement to start collecting and reporting those numbers, that would be most excellent, because we don't have a whole lot of sustainable Nevada data.
Thank you. And do you, for your purposes in setting policies, in providing services to victims, is it more helpful to have generalized statistical information, like between sexual assault and gross lewdness and revenge porn and internet stalking, we received a total number of 5,000 inquiries? Or is it more helpful to have them divided out and then you compile them yourselves? Which one is more helpful?
Serena Evans, for the record. I think the more specific we can be, the better. In order to actually address the problem and identify a solution, we need to have tighter data and more specific numbers. So if we know that there was, 2,000 people reaching out for revenge porn and 1,000 people for open and gross lewdness, we can then be able to kind of navigate a solution a little bit more strategically.
Thank you. Can I ask one more? Yes. Okay. Unrelated question related to a different part of your presentation on the TPOs and EPOs being denied at a higher rate. And I did see the statistics on there, and it looks like just numerically we are seeing fewer being granted, but we're not seeing fewer applications. And so, and those were statewide statistics, right? And I can appreciate, I'm thinking about this, from my own perspective, how shall I say this? The sensitivity of, picking out particular judges or particular jurisdictions or particular places where these are being denied at a higher rate. But are we seeing that there are particular cases or particular places where they're being denied at a high rate, or is this across the board? We've just seen a decrease. And let me clarify, I'm not asking you to name names. I don't need to know what jurisdictions. I'm just asking if we can see that or if it's inexplicable.
Elizabeth Abdur-Rahim, for the record, I would say that rather than saying, are there places where it's particularly egregious, we can say there are a few places where people are doing it all right. Right? And I think that we want to be careful. Yes, we do hear from our members like, this judge we're having a really hard time with, and we go in and we try to do a lot of education and we try to see if we can make changes right in that specific place. But what we're seeing really is like across the state, we're having these egregious problems, and then we get some communities that are able to make really good connections with their judges and really make progress. So, for example, it was a huge problem in Winnemucca. Their advocates were getting virtually none of their orders granted. Right? And they went and they just had the one judge, right? And they worked with that judge, and the judge said, this is what I need to see. And they cleaned it up, and now almost all of their orders are being granted right now, right? And so instead of saying, where is it particularly awful? I'll say there are a few places where they've made a ton of progress, but I don't think we see a lot of places, it's kind of awful all over.
Thank you.
Okay, we have one more specific question for Ms. Evans, and then Ms. Riley, are you coming back up to present?
I am after.
Okay. All right, so our next question is from Assemblywoman Gallant. She's virtual with us today.
Thank you. Ms. Evans, I have a question in terms, I guess I'm just concerned about Nevada's being ranked 5th in rapes and 2nd for domestic violence in the country. So have we identified why Nevada is rated so high? And then if we have, or whatever those factors are, is that being factored into the prevention programs that you guys are looking at? Because I would rather we just not have it than to be dealing with it in the aftermath.
Thank you for the question, Assemblywoman Gallant. Serena Evans for the record. Domestic and sexual violence is extremely complex, and so there's not one specific issue where we can target it to. Part of what we do at the coalition is we have a statewide economic justice work group, and we're looking at community prevention. We are looking at community supports that we know lead to decrease in violence risk factors. And so we've narrowed it down into 5 umbrella buckets. And so it's housing, access to mental health care and health care more broadly, funding and revenue, reproductive freedom, and then workers' justice. So when we talk about workers' justice, we're looking at fair, equitable wages, available childcare, things like that, because we know that the more economically, financially self-sufficient an individual is, the less likely they are to be a victim and or be dependent on a perpetrator. And so we are looking very broadly at prevention efforts. I think one thing we also need to have a conversation about is that there is no mandatory prevention education in our K through 12 schools. We know that young folks, abuse is a learned cycle. If they don't know how to name abuse and change their own learned behaviors, they are more likely to perpetrate it in the future. And so we do need to have a conversation about how do we educate our young folks and how do we get prevention and healthy education relationships into our schools.
Elizabeth Abdur-Rahim, for the record, I would just like to say, again, we understand that this is not a funding committee. There's a direct correlation between states that are addressing domestic violence and sexual assault well and states that have line items in their budgets, right? We are one of the very small handfuls of states that continues not to have line items for domestic violence and sexual assault, and we continue to be on the top of the list. And those things are related, and if we don't say that out loud, we are really missing a vital part of the formula.
Can I ask a follow-up question?
Quickly, please.
So I appreciate the everyday living components that you guys are identifying, but somebody who has worked with victims of domestic violence, there's the other psychological and the mental health component where there's this cycle. So, and I've had plenty of tenants where we've got Section 8 and the housing secure, and they're still ending up in these cycles of violence. So is there any component or any part of the prevention component in terms of the mental health component and for the prevention programs?
Serena Evans, for the record. Yes. So access to mental health for both victim survivors as well as perpetrators is one of our main components of our prevention work. So we know that individuals who have unaddressed and undiagnosed mental health illnesses are more likely to be targeted by perpetrators because they're extremely vulnerable. So yes, access to mental health is definitely an area that we focus on in our prevention work.
Sorry, Elizabeth Abdur-Rahim, for the record. But also thinking about healthy relationship curriculums. It's something that's come up. It comes up across our state all the time, right? And we're looking at it in the Committee for Domestic Violence at the AG's office. But sex education is one thing. Healthy relationship education is something different. And we know statistically that your first relationships that you're having, right, in your adolescence often become the model for your relationships across your life. So if we can get in and do that prevention work in the beginning, it will make a huge difference. But right now we don't have that across Nevada. It's hard to get it into the schools.
Okay, thank you. And with that, we're going to go ahead and switch out. We're still under the same agenda item. So, Ms. Riley, if you would like to approach as well. Okay. All right, so we are, Ms. Ortenberger, are you beginning? I am. All right. And then we will also hear from the Attorney General's office. So please proceed.
Liz Ortenberger, for the record, LIZORTENBURGER. I am the CEO for SafeNest. We are the largest provider of domestic and sexual violence services in Nevada, focused primarily on Clark County. I hope to get at some more of the nuance and particularly Assemblywoman Gallant's questions, because what is happening in our state is massive. 28,000 cases of domestic violence, second only to minor infractions for moving violations. But that only represents the 15% that are actually arrested. We work in partnership with LVMPD's data. So this is a fraction of the actual 911 calls that are happening in the space. So 15% of the 911 calls are represented in the uniform crime statistics because 70 to 85% of those calls do not raise to the level of arrest. Again, with 73 homicides, and 22,000 of that is happening in Clark, 56 homicides in Clark last year. But there are solutions in this space, and there's some things that the legislative body has already done, but they need to be enforced. So when we look at domestic violence and prevention, it has to start with children. 76% of kids growing up in domestic violence households will repeat that cycle on both sides, as survivor or as perpetrator, and sometimes as both. These are the numbers from the national crime, from the uniform crime stats about how many children were on scene of domestic violence 911 calls in our state last year. We passed SB 80 in 2019. If law enforcement responded to a case where school-age children were on site. They needed to call Safe Voice. This is simply just not happening. So what this means is schools, school counselors, and the body that is there to support our children is unaware that they are in homes where there is an arrest made. We can solve this by Safe Voice providing data to those of us in the field to partner and to the legislature to say, what are we doing? And then we can work with law enforcement and the advocates to start ensuring that officers are doing this work in the field. The number one place for us to catch these kiddos is school. And imagine your mom or dad was arrested Friday night, you're at school on Monday, and there's a trained therapist there to talk to you about the domestic violence. Not only that, that therapist becomes an advocate for the family and connects them with additional services. This has got to be part of the safety net in our school system. We have worked extensively with the school system in this space, but until law enforcement plugs in and all the pieces are working, and the legislative body is the right body to call and ask for those reports. The other place our state has incredible opportunity, and you heard me present on this in February, so I will be brief. The bottom line to domestic and sexual violence is it does not end until the abuse stops. The abuse does not stop until the abuser stops abusing. If we continue to have survivors only services, we will continue to have a tidal wave of abuse, because whether or not as a survivor you're able to exit that circumstance, you've created a vacancy for a new survivor to be created. So until we start to take batterers' treatment seriously in the state of Nevada, we will continue to be second, fifth, or whatever that looks like. The academic models, the evidence-based models around batterers' treatment show that it works, but it needs to have robust elements that include alongside partner programs for the victim in the space. I will tell you, SafeNest, 50% of my residential survivors are going back and staying back. We have got to figure out how to make these households safe. There should be a committee on batterers' treatment that is robust. There should be a certification program for those of us providing that can be run by one of the universities. We as providers should also have to pay a fee so that our programs continue to be the highest level in the state and accredited, and we can fund that as a state. The data needs to be pulled and tracked and studied, and so that we can continue to improve these programs. The facilitators running these programs have got to be academically certified. The requirements now are very loose, and so we will be bringing legislation forward this next session to fix this. We also need to use the R&R framework, which is out of the prisons but incredibly effective in batterers' treatment. This is being piloted in Australia and England with phenomenal results. And as you've heard in family court, but I will tell you the same is true in criminal court, we absolutely have to hold judges accountable for the decisions that they are making around domestic and sexual violence. So when we talk to survivors, we ask survivors on average to do 63 individual steps to flee their abuser. This is an overview of what that process can look like for a survivor, and we ask survivors regularly to do all of these things. Any of these fall through the cracks. You're losing your children potentially to CPS. Maybe that TPO isn't approved. I will say Barbara Buckley's team at Lawson does a phenomenal job with this data. The number one reason extended protection orders are denied is because the survivor doesn't show up. And when we poll those survivors, the number one reason they don't show up is financial, because they need the abuser to help fund the household. So when we start to look at those complexities and we say, why doesn't she or he leave, we start to understand it a little better. But this is just an overview of the steps survivors have to take. Speaking on a SafeNest specific level, we denied shelter to 530 survivors last year. That includes 1,863 primary survivors and 3,167 children. So when we ask, why is domestic violence bad here? I could not help 3,167 children exit their domestic violence circumstances last year because I simply don't have the resources. And these are survivors that have at least one lethality marker. We use an evidence-based 0 to 11 point scale. You have to have an 8 or a 9 to get a bed with me. I will also tell you in this space that SafeNest, when we talk about trafficking in its intersectionality with domestic violence and sexual assault, SafeNest spent over $346,000 on hotel rooms from Formula One to the Super Bowl this year. When we talk about sexual violence and sex trafficking, it does not look like we think it looks. It looks like a 16 and 17-year-old calling me who's been here, trafficked here from LA in a truck, came here in a big rig, severely abused, has been stabbed 3 times, and they're calling our hotline for help and support. We continue to believe these things stand alone. They do not. 90% of sex trafficking overlaps with domestic violence because there's a relationship with the trafficker. And sexual assault falls into a similar profile. But there are solutions. We've been working closely with the governor's office and the state to build a facility or acquire a facility here in Clark County that would function as one safe place for all interpersonal violence survivors to come and get services in one place. Why do we do this? Because last October, we had a survivor call, get an emergency temporary protection order from us. My staff did all the things they're supposed to, offered shelter, offered follow-up. She denied everything. We gave her the ETPO. Her abuser was arrested at that point on strangulation charges, but with no exam. So he was released because she didn't want to press charges. Why? Because she had 3-year-old and 2 6-year-old twins. What happened in February? She finally ran out of money and needed to leave the Airbnb where she had been. She called him and asked him for help. He came home, stabbed her in front of the children. The next morning, the 6-year-old figured out how to call grandma on FaceTime, showed grandma the dead body, and police responded. He was arrested 3 weeks later in Kentucky. This is what is happening here in Clark County because we don't have the resources to house people with dignity so that they can escape their best domestic violence circumstances in a way that does not lead them to homelessness. So this space, this one safe place, provides an opportunity for that because the change is a survivor walks in and is wrapped around with services. And because we can pull all the collaborative services together and the Hope Campus, which we're working closely on with that team, we can find housing for folks differently, but we can at minimum let folks know what the services are available and they have a place to come to find safety. Finally, I really want to thank you all for passing the strangulation bills that we did last session. We will be working this session, and we've been working with UMC through partnership with the county to fix some of the nuances of that legislation. First, I would like to share that Dignity Health provided publicly on the TV that they don't want to have a forensic nurse because that's too much of a liability. So what we're comfortable doing is putting sexual assault survivors and strangulation victims in Ubers and sending them to UMC where they're waiting 8 to 23 hours for exams. And I have 24/7 advocates at UMC there to help and support. I cannot speed up how long one forensic nurse is able to do these exams, though. So moving forward, what do we need to do? Any hospital or clinic that is receiving funding from the state in form of Medicaid or any other funding should be required to have a 24/7 forensic nurse response. We also have to remove the mechanism where billing for this has to go through the county. Providers need to be able to directly bill the state. And then we need the positive steps that are happening is UNLV has a forensic nurse training program starting up, and the International Association of Forensic Nurses is heavily engaged with the work here now. It is now simply opening the floodgates and requiring the hospitals to do their portion of this work. Thank you. Happy to take any questions if there are any.
Oh, we're going to have you hang out for a little bit, and we're just kind of doubling up on this presentation.
There you go. I'm not 100% sure. I'll be back, I think, if we just close.
Good morning, Chair Miller, Vice Chair, and members of the committee. My name is Lauren Boytel, Lauren Boitel, and I am here speaking today on behalf of the Nevada Policy Council on Human Trafficking. Just some overview on the Policy Council. We are the only permanent statewide policy council for human trafficking in Nevada. We were founded just ahead of the 21 session in 2020. Our mission is to advocate for just and equitable policy solutions through education, collaboration, coalition building to improve the state and federal anti-trafficking systems. And the purpose is really to convene community stakeholders to develop and identify policy solutions to sex trafficking and labor trafficking in the Silver State that can be implemented through legislative action and business investments. Our membership is very diverse. We have survivors, service providers, law enforcement, gaming, healthcare, attorneys, legal system, basically, yes, lobbyists sometimes. It's a very diverse group of people, and our steering committee here represents that with myself, a board member, a survivor leader, some service providers, the largest service providers in the state. Just want to talk about the statewide impact over the past two sessions. I know most of you are familiar with this, some of you intimately familiar, but I want to really make the point that human trafficking has only existed as a crime in Nevada since 2013. So we've made significant strides in a decade. And I wanted to point out specifically in 2021, extending criminal responsibility to businesses who facilitate sex trafficking, increasing the statute of limitations for victims from 4 years to 6 years, and then licensing and certifying the receiving centers. And that's important because of a policy agenda item I'll bring up quickly. In 2023, again, 3 bills that we supported were passed and signed by the governor, introducing early screening to better identify at-risk youth, prohibiting the courts from imposing fees on victims for things related to the crime, such as record sealing, fingerprints, fees such as that, so reducing that financial burden on victim survivors. And then mandating the creation of a biennial report and significantly a $1 million allocation from the general fund to support victims, specifically housing, and extending the statute of limitations for access to that funding. So really wanted to point out that there has been significant kind of strengthening of our human trafficking policies in the state, but there's still a lot of work to do. And so we've developed a policy agenda as a policy council, and this agenda is a 3-pronged approach. It is focused on victim survivor resources and support, demand reduction, and then strengthening the system. The policy agenda has been developed so far through strategic planning of our council members, as well as focus groups with state leaders. The first prong is the increasing support and resources for victims and survivors. So again, we've made some significant strides, increasing resources and protections, but there's still a lot of work to be done, specifically around housing, as we've heard so much today. Housing and shelter is the biggest need for adults and children, as well as those wraparound services that are so important for their continuing that journey. I want to point out on this piece, the victim survivor support, that I do think there has been a sea change in the understanding and education of our state lawmakers in recognizing that trafficked persons are not criminals and they are victims. So I just want to thank you for that. And I think that that is shown through how our policies have been strengthened thus far. So we have 4 main policy recommendations under victim survivor support and resources. The first one is creation of a mechanism to allow minor victims to be held securely for at least 72 hours without a mental health hold. This comes specifically from law enforcement because they really feel that that 72-hour period is that threshold where they're able to see a change in that relationship with the victims. They start to establish trust. They start to be willing to speak more. And so at least 72 hours, and something we're kind of looking at is something similar to the CHINS hold, which is a child in need of supervision. And it's a hold that law enforcement is able to use for out-of-state minors just until their parent or guardian can get into the state. So if we could look at expanding something like that for child victims to allow that relationship to be built between law enforcement, that trust to be established in some safe way that doesn't have the implications of a mental health hold. Our second policy priority under victim survivor support and resources is funding the receiving centers. So again, housing and shelter being the biggest need here. All of the protocols, processes, security procedures were set up in that legislation passed in 21. We just need to fund them. And there is a huge need. Another thing we'd like to see is required curriculum in the schools. That's been brought up a couple times today as well. We thought we could start with funding a pilot program, possibly with education funding, choosing one school in the north and south to start, and the schools with the highest number of identified victims, and do a pilot program to see how the education from elementary school through high school, how that sort of changes the outcomes. And then possibly a state-funded scholarship program for survivors of human trafficking, something that helps them continue along their survivor journey. And we thought we could look at something akin to the Millennium Scholarship. Our second prong is, decreasing demand through harsher penalties for buyers and traffickers. So this piece is really important because we think the best way to decrease demand for purchased sex in the state is to increase the penalties on buyers. Buyers create the sex trafficking and sex purchasing market, and they are the best intervention opportunity for decreasing trafficking and victim exploitation. So we have two main policy priorities under this prong, and that is a passable demand reduction policy focused on increasing the level of the penalty and the fines for buyers. I know that there was a lot of work done on this last session, but I really think we need to move that forward, especially repeat offenses. We're always going to get kind of pushback from folks who use ignorance as a defense, or we don't want to ruin someone's life for one mistake. So I think we can especially look at those repeat offenses and definitely increase the levels of the penalties and fines there. Related to that is increasing the length of time for buyers to seal their records. Right now, buyers can seal their records after 1 year. So a lot of people who are coming into this community for annual conventions, they can purchase sex and seal their records within a year and come back and do the same thing. So if we at least increased that, then we could charge those increased penalties and fines for those repeat offenses. The third piece is strengthening the system. The human trafficking response system here, as noted, is still young, small, and is underdeveloped. It does not meet the needs of victims, survivors, the service providers, law enforcement, lawmakers, and other stakeholders. So we really want to support strengthening that system with funding, with increased capacity, and with data. Four main policy priorities under strengthening the system. Permanent increased funding for victim, survivor, housing, and wraparound services. Sorry to be a broken record here, but that is just the biggest need. Funding for data collection via a state human trafficking management information system. So we have one for homelessness. It is a very robust system, more than one in the state, in HMIS, and it's very robust with queues of identified people and all of the wraparound services, inventories for beds and services, where they're at in that kind of pipeline. And I think that would be so useful for our state to truly start to grapple with these numbers that we all get from various sources and try to put together. It would allow us to integrate that system with other management information systems and other databases such as juvenile justice or the justice system in general. And we could truly track the path of a victim survivor from, say, starting out with childhood trauma of domestic abuse to, maybe being homeless, to being a trafficking victim, to the justice system, and then that continues. And we could see where those intervention points could actually make a difference. So I think just truly being able to have good quality, accessible, transparent data would be the biggest thing to strengthen the system. Required trainings for all mandated reporters, foster parents, judges, attorneys, teachers, law enforcement, first responders, nurses, mental health providers. It can go on and on. Basically, the point here is at any point when a victim could be in touch with possibly the first trusted adult or a professional that has the power to change the course of their life. Those people should have some sort of foundational training in this issue and the trauma that this population experiences. And so some sort of required trainings for those individuals, those professionals, at least a foundational understanding. And then the final piece here is a broad swath NRS language change to remove references to child prostitute or children engaging in prostitution. And we have some research of every case in NRS where that exists, and prostitution just implies a choice, and children are not at the age of consent and they cannot make that choice, so children do not engage in prostitution. Children are victims. I think. And that's it for my presentation. I believe Nicole's going to go next.
I don't have to trade seats with you. Good morning. Thank you, Chair, Vice Chair, and the committee members. Nicole Riley with the Attorney General's Office, Ombudsman for Domestic Violence, Sexual Assault, and Human Trafficking. I'm here, I'm going to be presenting on behalf of the Washoe County DA's Office and the HEAT team, which is the Human Exploitation and Trafficking team in Washoe County. I'll start with the letter that the Washoe County DA's Office sent to me. April 24th, 2024. When you think about sex trafficking, you probably picture a young woman walking home from school or work and being snatched off the street by several masked men and taken away in some nondescript van. While that certainly can and has happened, that is generally not how sex trafficking offenses occur in Nevada or what I have seen in Washoe County. This is from their special prosecutor on sexual assault and human trafficking. I have been the lead prosecutor on nearly all sex trafficking cases submitted to the Washoe County District Attorney's Office for the last 3.5 years and have come to realize that sex trafficking is far from what you see in the movies. It happens much more secretly and often evades detection for years. A trafficker or pimp generally targets someone with a vulnerability such as drug addiction, mental health issues, financial instability, lack of strong family ties or emotional support, and exploits that vulnerability. The victim often has no idea that they are being exploited. Traffickers manipulate victims by providing them the drugs they want, the money they need, or the love that they have been searching for. As a result, they feel indebted to the trafficker and they end up doing whatever they are told or encouraged to do. Include selling their bodies to strangers for sex. In my experience, many sex trafficking victims share a history of childhood trauma and sexual abuse. Survivors of childhood sexual abuse can lose their sense of bodily autonomy and may be persuaded by traffickers to sell a body they no longer feel like is even their own. While I cannot speak to the statistics relating to sex trafficking offenses in Clark County or statewide, I do know that in Washoe County, 100% of all juveniles contacted by detectives with the Human Exploitation and Trafficking Unit, the HEAT unit, between 2020 and 2024 were found to be engaging in prostitution. Who were found to be engaging in prostitution were doing so under the control or supervision of a trafficker. This statistic is staggering and disturbing, but unsurprising because children are especially vulnerable to the emotional and financial manipulation utilized by traffickers. So how do we break this cycle and work toward protecting our most vulnerable Nevadans? It comes down to economics, supply and demand. The sex trafficking economy is driven by the demand for sex workers. The greater the demand for paid sex, the greater the number of traffickers and the victims they exploit. The lower the demand for paid sexual transactions, the lower the number of traffickers. We can reduce demand by targeting Johns and sex purchasers. They must be held accountable for their role in further exploiting the vulnerable population of our communities with meaningful criminal penalties. But the scourge of sex trafficking would only be exacerbated by decriminalization or unregulated prostitution, driving up demand by allowing traffickers to freely advertise their victims' bodies without fear or threat of arrest or prosecution. That's from Darcy Cameron, Deputy District Attorney, Sexual Assault and Human Trafficking Prosecutor at the Washoe County District Attorney's Office. The next bit of information that I have is from the HEAT unit. They let us know that in 2023, the total arrests were 121. Total arrest counts, 307. Felonies, 286. Misdemeanors, 21. No filed cases, 2. This really shows the severity that occurs when you look at the charges. 286 felonies as opposed to 21 misdemeanors. That shows the significance of the violence that is occurring in this space, actually. It's not minimal. It is severe. It is life-threatening. The victim stats, so those were the perpetrator stats. The victim stats, 2023. Victims referred / tips were 419. Adult victims served 337. That's just Washoe County on the ones that they're catching. Juvenile victims served 79. Homeless 62, and mental health 27. Victim recovery options for 2023, victim recoveries 83, juvenile recoveries 31, adult recoveries 52. The ethnicity Caucasian is 260, African American 65, Hispanic 76, American Indian or Alaskan Native 2, Asian 7, and Native Hawaiian or Pacific Islanders 5. In custody, so first I want to stop there because then they go on to their new program that they created in the Washoe County jails. So on their first part, which is all of their operations for human trafficking and exploitation, I'm working with that team, a researcher from UNLV and a researcher from UNR. To track this data and try and put it in, like Lauren was saying, into a understandable, concise, evidence-based report. What the conversation we had was, how many of those do you have sex workers that identify as independent, free from a trafficker? Their response was, oh yeah, we definitely do. But they're not keeping track. They haven't kept track of that number. They are currently going to start keeping track of that number. Another question that they're asking is, though you're independent now, have you ever been trafficked in the past? We're going to get that number, which is almost 100% of them have that we come into contact with. For those that are identifying as trafficked, they're going to be asking the question, at any point in time, have you been an independent sex worker? And what happened that occurred from you going from independent to being trafficked? They're also going to dig in deeper and find out, were you trafficked, then went independent, then trafficked again? We're really going to be able to show the pattern of violence and abuse that occurs within this industry and the grave misconceptions that people have around Johns and sex work itself. Another disturbing case that we became aware of was regarding OnlyFans. And they discovered that there was a couple who had promised tons of money and they would just help the women out with developing their OnlyFans and marketing it and for a very small fee. And so several of these women finally came forward. These traffickers set up their accounts, kept all of their passwords so they actually couldn't do anything on their accounts, set up the funding to go straight to the trafficker's account and not to the victims that were being exploited. And they took over 1.4 million from 2 victims that they were trafficking on OnlyFans. So this isn't just physical trafficking that is occurring in person, it's occurring online on websites like OnlyFans. And those are identifying as independent workers. And then when we dig into the background, because they don't know they're being trafficked, they have a different understanding of what trafficking is. And so when we dig in and we educate them on what actual trafficking is, they are suddenly stunned to find that they actually are victims and have to start dealing with the issues that exploitation has, the impact that it has had on them. So we're looking forward to getting all of that data put together so that we can really see what the picture is of a person that is working in sex work and the reality of their life. They're also going to be tracking when their first violence occurred and what type of violence that was. We're finding that in our service providers, they do track that data. 96% of the victims they serve, their first sexual assault occurred around 3 or 4 years old. And then they continued to have violence after violence after violence through their entire life. They go into adulthood. They have no skills, no social skills, no work skills, and so they resort to survival sex. And that's what this is. I have never asked someone, gotten the response from someone that I asked is, if you had a choice to go and get an education and have a job, let's say be an attorney, would you choose to do sex work over that? No. Not one single one of them said they wanted to sell their bodies to strangers instead of having, a great education and legitimate work that could provide for their home. So that being said, we're moving on to the advocate program that the Washoe County, or the HEAT team, started in the Washoe County Sheriff's Office on September 1 of 2023. Since that time, 298 victims in custody have disclosed being trafficked since the program started. The HEAT advocate provides services in custody and support when they are out of custody. So these 298 victims were in custody under what was considered unrelated charges. And then when they were interviewed, it was discovered that they committed those crimes because the trafficker was forcing them to, either through threatening their life or their children's lives. 100% of the victims who have disclosed being trafficked, every single one of them have had a past sexual assault. 100% of them out of 298 victims. And those are the only ones we have access to. And then the last point was 90% have disclosed being in a domestic relationship with their trafficker, which adds to the point that Liz made. And then also to Lauren's policy agenda of the data collection. We will be also adding in if it was a domestic relationship as well, so that we can show the intersectionality of sexual assault, domestic violence, and trafficking. One thing that I am going to be suggesting to Attorney General Ford, which I know he will immediately say absolutely yes, is to do a fatality review team around a trafficking fatality. So we do that for domestic violence already. We look at their lifespan, find those intersections that Lauren was talking about where we could prevent or intervene, and we'll be doing that the same with the trafficking data and then showing the intersectionality of that and the severity and why we need to stop siloing each one of these experiences and see that they cross all together. So that is it for the presentation from the Washoe County District Attorney's Office and the HEAT team, if you have any questions.
Thank you so much, and I would just like to suggest that when it comes to those fatality reports, something I just experienced is that the fatality is not always necessarily as direct as we assume, like a shooting or strangulation. There's actually chronic conditions that can come from chronic abuse that also causes a fatality. So let's just not look at the most obvious.
But the problem is we don't know that there's no tag on those, that they're in a domestic violence relationship. So we don't have access to their info and discovery because specifically in statute, it's identified cases of domestic violence. If we had access to medical records like we did on that one review case, and that they were being tagged as DV, and we actually did see that some hospitals had tagged her as DV and some mental health providers tagged her as DV, and no one gave her resources. So that was super helpful, and seeing all the opportunities for intervention that occurred in the medical realm, not even in the criminal justice realm. So we'll be looking at expanding that statute so that we can work with Department of Health and Human Services to get that data as well.
Thank you, because I think we see that I know they see it in the medical profession as well as we see it in the schools.
It's been well documented.
Yes, it's well documented. We know, and whether it ever gets, again, once it becomes part of the investigatory, or, it may never make it to the criminal justice system, but
we know.
Medical and educational practitioners know that these things are going on. And so, again, the record of all of that would support that.
Definitely. I appreciate that comment.
Yes,
so I'm going to go after it.
Yes. To look at everything. The same thing we look at, there may never be an arrest, but how many 911 phone calls were made?
Right. Exactly. Or were they identified in the healthcare setting? Never made a 911 call, but they have all the medical conditions, which this particular victim had. Diabetes, heart condition, obesity, all of that. And she was marked as DV through all of them, never got services, and then we wouldn't have had access to her medical records that gave us all that extra information. So that's a great idea. Thank you.
Thank you. With that, we will start with our first question from Assemblywoman Gonzalez.
Thank you, Madam Chair. Good morning. Thank you for your presentation and being here today. I had two quick questions. You started off the presentation talking about how law enforcement was not making a call, or was it tagging a stat or something of that nature with children? What is the barrier to that, and what have you it seems like you have a working partnership, right? Because you talked about like working together with data and things like that. So what is preventing this specific issue?
Yes, so I will say again on the record, we have a phenomenal working relationship with LVMPD, and we're very, very proud of that. The issue is more one of 2019, it passed, and then COVID, and it's not being enforced, right? And so it's more of an issue of, yes, I can certainly go and meet with the sheriff and we can have these conversations. But what we need to know is from Safe Voice, what is happening, and then how do we target and train to have it happen? Because the corollary concern that folks have is it will crash Safe Voice, to which I answer, great. Let's break it so that we can fix it, because that is the first line of defense for our kiddos. So we need the data from Safe Voice, and then we need that to be brought to the sheriffs and chiefs and through the committees like yourselves, like this is a mandate from the legislature and we want reporting on it.
Thank you so much. And my second question in your presentation, under the policy agenda, number 3, it talked about funding a pilot program in schools with the highest number of identified victims in North and South. Do you know what those areas are already? Like, do you have data on, okay, in this zip code, we have the highest number of victims? Does that already exist?
Lauren Boytel for the record. Yes, thank you for the question. Yes, that is being tracked by school.
Any additional questions? Not seeing any. Thank you all for your presentation. This was a lot under item 5, but thank you. Everyone's like, oh, we're still on the same item. Yes, we are. Thank you so much, everyone who presented with this. We will move on to our next agenda item, which is agenda item 6, an update on the reporting requirement in Senate Bill 389 from last session, and it's a comprehensive biennial report on human trafficking in the state. We have Dr. M. Alexis Kennedy, who is a professor in the Department of Criminal Justice at the University of Nevada, Las Vegas. So, Doctor, when you are ready, please proceed.
Thank you. Thank you, Chair, Vice Chair, committee members. Despite me being a professor and academic, I will be the shortest report today because we were looped in with SB 389 to do the biennial report, and we will be producing one in the summer, but it has been a lot more challenging to get people to participate in this process than we realized. So we went through the process of setting up the ability to share secure data, doing memorandums of understanding, doing scope of work, securing a computer and a dedicated office. And the first group to participate was the Division of Child and Family Services, who arguably have some of the most sensitive data, but we got everything in place, and we've been receiving their data now for 2 years. But I'm not going to present because Ms. Janos will be on a next agenda item, so she's going to present her results. So we only have data on the children that are screened through DCFS. I came to this, being the data lead through the children's, the CSEC task force. What the SB 389 was expanded it to children and adults, as well as sex trafficking and labor trafficking, but there hasn't yet been any coordination with the other groups that might have this sort of ability to access the data. But we're now meeting with the AG Ombudsman is going to help pull all the different diverse groups together so that we're not all working at cross purposes. But speaking about sort of failed initiatives over the past year, we did meet repeatedly with law enforcement groups and invited them to share their data. They politely declined because they felt that they can meet the letter of SB 389 by just generating their own reports. So the trouble is, if we have law enforcement saying, here's our rough estimate of what we're seeing, we can't match that against what the other agencies are doing. So SB 389, I'm sure there's going to be some policies that will come up to talk about how do we encourage agencies and non-governmental agencies to participate in sharing the data. So the system is there. It'll be a very thin report, the first one, but we look forward to helping in any way that we can to increase the participation of agencies in sharing their information with the Statistical Analysis Center.
Thank you for that. I'm just, I'm trying to think of the right. I'll say interested in when you're saying that law enforcement is not sharing the data, and I'm looking up the requirements of SB 389 to see what, okay, thank you so much.
July 1st.
Okay, so July 1st, but where does it start? Okay, these are the people. The State of Nevada Human Trafficking Coalition, Nevada Coalition to Prevent the Commercial Sexual Exploitation of Children, Nevada Policy Council on Human Trafficking or its successor, each local human trafficking task force, each recipient should submit by July 1st. Where does it state of law enforcement? Got it. So on or before July 1st of each numbered year, each law enforcement agency in the state shall submit to the center the number of arrests made or citations issued by the agency for a violation of NRS 201 or conduct related or human trafficking during the immediately preceding and biennium in the disposition of those cases. So you're saying that law enforcement has informed you that they're going to do their own report and not submit the data to you?
Well, what they're going to do, I think, is say we had 50 kids and 49 were female. They don't feel that the wording represents that they have to actually share the client information, the names, birth dates, identifying information so that we can do the purpose of a comprehensive database.
Okay, so you're saying they are going to provide you the data, the numbers, just not the personal information.
That's my understanding, is that they would generate their own summary report that they could present to the committee. Or I can forward it to you, but it's not going to be integrated because it's just going to be a numbers count.
I see what you're saying. So you're saying they're not going to match the same categories that you're...
Correct.
Okay. So we will talk about that because that was the whole intention of what is stated clearly in the bill, for them to provide that information.
Yes, because it's difficult to, we have now the structure to receive the secure data and the idea that we would receive it with personally identifying information so that we can check, who these people are getting services from. But yeah, it's a leap of faith to share that level of information, but DCFS has been able to do it, and we have the database created now.
Thank you so much for that. And Vice Chair Scheibel, would you like to, because this is your bill, would you like to have any comments?
I would love to jump in. And I so appreciate you coming and presenting. And I think we'll have some questions, some follow-up questions for the law enforcement agencies that are frankly not complying with the letter of the law and the intent of the legislation. And I can see some of them are hiding behind the column back there. So when they're ready, we'll make sure to address our questions to the proper, people to answer them, because it sounds like, and just, stop me at any point if I'm not understanding correctly what you have said so diplomatically, is that the system is set up and all of the necessary technological features are there to preserve the integrity of the confidential data, and that you have the staff, the support system, the resources, whatever it is that's necessary to receive all of the data and to produce a comprehensive report. What you don't have is the data input from the law enforcement agencies, and the bill is, of course, very broad. It says every law enforcement agency, which is intended to cover all of the, the county sheriffs, as well as the municipal marshals and the state level, if there are any state police officers who are involved in this kind of work. And I'm understanding that you have open lines of communication with all of the law enforcement agencies, and that they're simply not providing the data, even though you're willing and you have created a platform where they can input that data. And so I think that when we worked on this bill, it took a while to identify an agency or an organization that could kind of house such a sensitive database. And so I appreciate UNLV stepping up to the plate to do that. And I think that you have done a fantastic job in your part. And we will, follow up with those organizations that are not doing theirs.
Yes, because the bill does specify the specific information that is to be submitted, not just general numbers. So,
thank you. And to clarify, we haven't actually, there's sort of a little bit of a lack of leadership of who's supposed to be the stick that goes and shows up and knocks on the door. So with the working with the CSET group, when we hit the wall with our first law enforcement agency, I don't know if other agencies have then been contacted. It's like when you go to the first door knocking, get it shut, we sort of stopped at that point.
And I think this is a good opportunity to share, too, that this is really the intent of Interim Committee as well, is to see the progress on implementation with bills, and always an opportunity. The one thing that's shocking that we always tell first-time legislators is that just passing the bill doesn't stop there. You're still working throughout the interim to work with different agencies and stakeholders. So again, you have the bill sponsor right here who can speak the best to legislative intent, and LCB is always available. So when we come into those kind of challenges in the interim, that way we can help and add support in any way we can. And I'm saying this for everyone listening today as well, not just directed to this situation, but I think it's important for us to understand that's what the intention of something that we can offer during interim as well. With that.
Thank you.
You're welcome. Members, do you have any questions? We didn't even get to the questions yet. Any questions, members?
Yeah, I do.
Oh, who is that? I don't see. Oh, Senator Krasner? Okay, go ahead, please.
Thank you, Chair Miller. I appreciate you giving me this opportunity to ask a question. I have two questions. One, well, the first one's a statement. On behalf of our law enforcement, they're really doing a great job, actually, with identifying human trafficking and sex trafficking victims, arresting the Johns. So I think we need to give them credit for the great work they're doing, and that's in the North and in the South. That's for starters. Number two, I have concerns. I have privacy concerns for minors' specific names being put into some database. And I don't have the bill in front of me from last session, but I don't remember it saying the specific name of the minor has to be shared. And I mean, it's a minor. So why is it not good enough to do exactly what law enforcement is currently doing and sharing the statistics, the data? If we're weighing out, the importance of having data and the importance of privacy concerns of a minor and not sharing their name and putting them on some list and immediately putting them, in a database where their name is identified and they're just a minor, I have some real concerns with that. I think there really needs to be a balance there. So thoughts on that? Thank you. Or not, just a comment.
This is Alexis Kennedy. Just to answer that question, obviously there's going to be concerns, which is why the Statistical Analysis Center became the receptacle for that sensitive data. The Statistical Analysis Center for the state of Nevada there's only one of them. They exist in all states and they get federal funds all the time to do sensitive research. So we were able to meet all of those requirements to keep it secure, sensitive, and private to meet, the Department of Children and Family Services expectations. They probably have one of the highest benchmarks. And once you have those policies in place, this is the only way to look at and track children that are being served by multiple systems. You have to have some central place to pull down the information from juvenile justice, from child welfare, from law enforcement. So it has been done before, and the policies are in place to do it successfully and confidentially.
Follow-up, Chair, please. I certainly understand the importance.
Go ahead.
Thank you. I understand the importance of tracking anonymously child victims. However, I really I don't like to see this where we are now making the victim have the same record as the criminal, the perpetrator, and it's a real problem. Because a lot of times child victims get labeled, that data is shared if there's specific name is in there, and then they have a record. I know that we have somewhere in the NRS something that says that the victims are placed in with the same group of children in need of services or children that have been arrested and prosecuted, excuse me, and then that data is shared with colleges and universities when the kid's trying to get into college, because the college has a right to see if there's going to be anybody that falls under this statute who might be dangerous or on their premises. And it's because it's a broad paragraph, they're not differentiated. The victim is not differentiated from a perpetrator. It's very concerning for me, for juveniles, that you're sharing their specific name. I don't like that. There's privacy concerns there. So just my comment. Thank you.
It's Alexis Kennedy. If I might clarify, the data comes into the center with the names. The names are assigned an identifier that is in a secure database, and then the names are removed. At no point will any names come back out of the data center or the database. So there's just no way that those names would ever be shared in this context. They're only used to create that identifying number so that we can compare the same data point across different systems. But we're under FERPA and HIPAA requirements. We would never share a name. That would never come from our database ever.
And thank you for clarifying that. Just for the edification of the public that's listening, we know that this bill passed unanimously out of both houses. And so just to, for the edification of people listening now, because of course we did have, a hearing and go through these details. And so I appreciate that. Is there any additional questions from members? Yes, Vice Chair Scheibel.
On this privacy issue, there's just a follow-up that I want to clarify, that I'm understanding that this is the way that the database is set up, and hopefully you're going to confirm that it will achieve its purpose, which is that we have so many organizations and so many agencies in the state that do work with survivors of human trafficking, who address, human trafficking prevention. And the idea here is to say, if Senator Harris runs a safe house and I am, a detective, and Chair Miller is a, service provider. And Senator Harris says, I had 5 kids in my safe house this year. And I say, oh, I had 5 reports from kids this year. And Chair Miller says, oh, and I served 5 kids in my organization as well. The data center becomes the one statistical holder of information to say, either we had 15 children who reported incidents of trafficking this year, or we had 10 children who reported incidents of trafficking this year, and half of them went to the safe house, and half of them went to Chair Miller's, outpatient program, or 7 of them did both, 3 of them did one, and 5 of them got no services whatsoever. The only way that we can catch those 5 people who are falling through the cracks, who got no services whatsoever, is through the statistical database that matches up these points of comparison to say, oh no, we had a child who reported being exploited, who reported being trafficked, and that child never received services, or they were never directed to somewhere to live, or there was never a DCFS follow-up, or that child fell through the cracks. The only way to know that is with your data. Is that correct?
Yes, thank you. That's an excellent explanation.
Thank you for that. And with that, not seeing any other questions, we'll go ahead and close the agenda item 6. Moving on to our next agenda item 7, which is presentation concerning orders for protection against domestic violence, stalking, harassment, and sexual assault in Nevada. We have John McCormick, the Assistant Court Administrator for Judicial Programs and Services from the Administrative Office of the Courts of the Supreme Court of Nevada. And, okay, Mr. McCormick, are you in Carson right now?
I am in Carson. Thank you, Chair Miller.
Are you in the committee room? There you are. Okay. There you are. Hello, please proceed when you are ready.
Thank you, Chair Miller. For the record, John McCormick, John, last name McCormick. I'm the Assistant Court Administrator at the Supreme Court AOC, and just have some sort of data to go over a little briefly here on protection orders picked from FY19 to FY23. And just a little background here. Protection orders, there are several types of protection orders in Nevada, and you can see there on the slide with these, with their statutory sites. But we do have domestic violence, harassment in the workplace, protection of children, high-risk behavior, those being the red flag orders, sexual assault, stalking, and harassment. And all of these orders may be issued temporary, so the ex parte order, and I put that there because the initial high-risk behavior statute referred to it as that, or an extended order. And there are 2 types of orders here that don't have a statutory requirement to be reported to the repository at DPS. That's just sort of a news note there. Protection order jurisdiction in the state is a little sort of confusing, I think, at times. That can be found in NRS 4.370, Section 1, Sub M, N, and O. And it's sort of a bifurcated jurisdiction. Family courts have jurisdiction for domestic violence and high-risk protection orders in Washoe and Clark counties, except in the townships in Clark County under 100,000, so that's like Searchlight, Moapa Valley, Overton, etc. And then outside of those 2 urban counties, that have a established family court pursuant to Chapter 3, justice courts have jurisdiction to issue all these types of orders absent the family court jurisdictions. And district court does have the ability to take jurisdiction over a protection order proceeding via written order to a justice court. Generally, that's done in cases of like a divorce custody type of thing where the district court would say take jurisdiction over that protection order case going forward. And then also it's important to note if there is if the adverse party against whom an order is sought is a juvenile, then district court has jurisdiction in all counties because pursuant to Title V of NRS, district court is the juvenile court for the state in the state of Nevada. And that was in 2021 where we worked together with all the stakeholders here to get that bill passed to put that jurisdiction in the correct place. And a note on that, and going back to my initial slide, The protection orders for protection of children, that is an order that has to be applied for by someone over 18 against someone over 18 to protect a minor. So those are pretty uncommon, along with harassment in the workplace as an order type that's sought. Harassment in the workplace is extraordinarily rare. You can see here, it's a graphical representation of domestic violence temporary protection order requests. And you can see there, it's kind of hard to see, and hopefully you have this presentation. The vast majority of those requests occur in district court, meaning that the vast majority of protection order requests come from our urban jurisdictions in Clark and Washoe County, outside of those rural exceptions there. Down at the bottom there, you can see justice court. So the balance of the state, there's fewer requests for those type of things. In justice court, you can see here, this is a representation of dispositions since FY19. The orange being granted, yellow being denied, and green being other. And this, I'll talk about the limitations on this data in a little bit. But so that basically means that at the justice court level in the state of Nevada, we have a 65.5% grant rate, for lack of a better term, for domestic violence protection orders. And during this time, we also had 3,229 extended order requests. So, and actually people are able to request that hearing for the extended order when they file for the initial protection order on the form. High-risk protection orders, these are the red flag orders. They're also fairly rare in the state currently. You can see here that, in urban jurisdictions, the most requests we had was in FY21 with 15 requests for those high-risk protection orders. Those are the orders to remove firearms from an individual who's posing a threat. And then also you can see at justice courts, there have been very few of those requested, since the inception of that statute. Non-domestic violence orders, excuse me, you can see here, and non-domestic violence orders, again, that would be sexual assault, stalking and harassment, harassment in the workplace, etc. You can see that representation here, and what's pretty interesting about that is the grant rate for those non-domestic violence order types is significantly lower. It's 36.7%, and those generally would include stalking harassment, which anecdotally is probably the most sort of misunderstood order type that gets requested in situations that are not potentially meritorious, but again, that's anecdotal. There are obvious limitations on my data here. First, there were 347 total sexual assault protection orders requested over the 5-year period we're looking at this morning. And we track this as an extra statistic. And we do have data limitations, and obviously we're not going to be able to satisfy, I think, the need for data, which I'll talk about a little bit later. But we don't have enough information regarding disposition types or extended order dispositions because of the implementation of our statistical collection model in phases. And rather than belabor that and go back to the early 2000s and talk about data collection, just acknowledging that we acknowledge there are limitations on that we would like to know more, and that we are in fact working that way. But first, I'd like to mention our litigant self-help portal. This is pretty cool. We just launched it at the beginning of April, and this allows people to go on. There's a number of videos. We have a chat bot to go on and complete what we call a guided interview. And by completing that process, at the end of it, you'll have a legally sufficient pleading to file in court. So a person goes on here, files for, say, a protection order against domestic violence. It guides them through the process to make sure all the information that is required on the application is there and necessary, and then it generates that pleading to go to the court. So we're pretty excited about this. The chatbot feature is really cool. And we've been playing with it, obviously, to teach the chatbot what it's doing. But it did know that Duckwater was in Nye County, but it didn't know if you needed to go to Tonopah or if you needed to go to Pahrump to file the protection order, it's Tonopah. But that's just, and it's learning, so that's pretty cool. People will also be able to work, do divorce petitions, all those kind of self-help things. So we're pretty excited about that. We haven't even had it up for a month, so statistics are not necessarily readily available. But we're hoping that this does expand access to justice, allows more people in more jurisdictions to apply for orders from, their home, from a computer. It's designed to work on mobile as well, because in other states, particularly Kansas, for example, they found that the vast majority of people who are accessing their litigant self-help portal actually were doing it on telephones, so we made sure it works that way. And then with data, obviously, and I think I acknowledge that our data is not necessarily great in some of these areas, so we're working on a data repository. And the best way for me to explain this and how we're moving forward is currently we have a statistical reporting model that has what people have to report, a data dictionary, and then the individual courts fill out that form, or their case management system generates the report, and then that is submitted to the Research and Statistics Unit at the Administrative Office of the Courts, and they go through the data, and that's how we end up publishing the annual report, which we send all of you. But that model has inefficiencies, and while we've been recognized by the National Center for State Courts for our reporting and the improvements we've made in reporting over the last couple decades, it's still not necessarily there. So how the data repository will work, it's a different sort of approach. It's an electronic database, obviously, that will go out and interface with court systems to pull the data, and then on our end, we'll be able to do data visualization and all sorts of stuff to pull better data, get more sort of case level information rather than just the aggregate data we get now. So it's something we're excited about, but obviously it's going to take a while to implement and then get all Nevada courts on there. But that hopefully will allow us to get some better data to satisfy, I think, some of the questions that have come up during this hearing. With that, I'm happy to answer questions, and hope that wasn't too quick.
All right, thank you, Mr. McCormick. Are you ready for questions?
Thank you, Chair Miller, I am.
Thank you. I did like that visual, though, but the verbal's better in the minutes. So with that, members, do we have any questions? All right, Vice Chair Scheibel.
I want to go back to your non-DV TPO dispositions slide, because I think this is really informative. And I don't know how you would do this, but do you have a sense, either anecdotally or from the data, what the majority of those applications are for? Are they people... I'll just leave it at that. Do you have an idea of what the majority of those applications are for?
Thank you, Senator Scheibel. John McCormick for the record. It's my anecdotal sense a lot of them would be stalking and harassment. And stalking and harassment is kind of a different order type, because a lot of times people try to say, I mean, this is somewhat inelegant, shoehorn it into another type of dispute, like a civil dispute or neighbors with barking dogs, right? And then they try to, one of the parties may apply for a protection order in that case, and barking dogs aren't necessarily stalking and harassment, so that would then be probably denied. But again, I think it's probably mostly stalking harassment, but again, that's anecdotal, and that is obviously one of the limitations of our current data system that we're hoping to correct. We could potentially poll some courts and see, just kind of get a sense from them what exactly is going on there. But again, anecdotally, domestic violence, stalking and harassment are the two highest, the most applications are for those particular orders. We don't get a ton for the protection of children now that the jurisdictional situation as far as minor adverse parties has been cleaned up statutorily. And then harassment in the workplace, like, I can't remember the last time I talked to a judge who said they'd ever had one of those, because it's a very different kind of order. And what it does is, say I have a member of my team is experiencing a situation where a protection order is necessary, but for whatever reason that individual, it doesn't apply or whatever. And this allows the employer to apply for a protection order, but it also requires a deposit and a number of other things. So it's a very kind of odd order. And the same with protection of children, again, now as we've fixed that. But that was a long and belabored way of saying I think it's stalking and harassment, but I'm not really sure because it's all anecdotal.
And I also just want to clarify, for all of our edification, we would expect, even in the best of circumstances, that there would still be a significant portion of denied petitions simply because there are situations that don't meet any of the criteria. And so I think what I'm trying to get at is there will always be people who come to court and ask for this remedy and say, hey, I want this person to stay away from me because they smell bad and I don't like them. And that's simply not a legal reason that a court can impose on that other person a requirement that you are no longer allowed to be within 100 feet of Melanie just because she doesn't like you and she says you smell bad. And so we would always expect to see at least some portion of those applications being denied because they don't meet any legal reason for implementing a protective order. Right?
Thank you, Senator Scheibel. John McCormick for the record. Yeah, that is absolutely correct. In order to get these orders, you have to meet the statutory qualifications on this slide, or not, that's jurisdiction, sorry. For example, harassment in the workplace describes those conditions. Sexual assault, again, explain the conditions upon which an order can be issued. So say a person, in the example you provided, applied for stalking and harassment because they thought some individual was not the most odoriferously pleasant. That obviously does not meet the statutory qualifications in Chapter 200 for a crime against a person and then would be denied. So you are 100% correct. Thank you.
All right, thank you for that. Not seeing any additional questions, we'll go ahead and close the item. Agenda item 7. Thank you, Mr. McCormick. We will move on to agenda item 8, which is presentation from law enforcement on human trafficking, domestic violence, and sexual violence in Nevada. We have Lieutenant Greg Flores from the Las Vegas Metropolitan Police Department. And we'll give you a few moments to, because I know there's a PowerPoint you need to hook up and such, and we'll give you all a few moments, and when you're ready, please proceed.
Just like to thank the chair and the committee for a few minutes today. We appreciate it. My name, for the record, it's Sergeant Greg Flores, G-R-E-G, F-L-O-R-E-S. Also with me is Lieutenant Brian Boxler.
Thank you, everyone. B-R-I-A-N-B-O-X-L-E-R. And I have the privilege of serving with Sergeant Flores on our Vice Human Trafficking section here with LVMPD.
Okay, we're just going to give a presentation of what we are seeing in Southern Nevada, reference human trafficking, specifically with our Vice section and our Southern Nevada Human Trafficking Task Force, as well as our FBI-led Child Exploitation Task Force. This is a heat map of the demand side of prostitution. Should be known that human trafficking right now is the second largest criminal industry in the world, right behind drug trafficking. And according to the U.S. Department of Health and Human Services, it's the fastest growing criminal industry in the United States. Our vice section, this is what we're comprised of. We have 1 lieutenant, we have 4 sergeants, we have 26 detectives, we have 1 law enforcement investigative specialist, 2 law enforcement technicians. We have recently added a sex trafficking task force coordinator full-time and a part-time coordinator. And we also have just recently added a financial analyst. We're part of the Southern Nevada Human Trafficking Task Force, which is partnered with the FBI as well as HSI, and we are part of the FBI Child Exploitation Task Force. In addition to the Metro detectives and the HSI and FBI agents, we also have a full-time Clark County School Police detective that's assigned with us. We have 1 part-time Henderson detective as well. Also, we have a partnership and a MOU with Advocate Services, and our number 1 advocate that we use on a daily basis is Signs of Hope Rise. Anytime we come in contact with a victim or a potential victim of trafficking, we have that non-governmental resource available, and they will speak with everybody that we contact. That is 24/7. Myself, my detectives will respond 24 hours a day, 7 days a week to a victim or a reported victim. Along with that, those RISE advocates will respond with us. In addition to the task force, we're also part of a Department of Justice task force. It's an OVC task force. It gives us access to other task forces throughout the country. As we see, this isn't a crime that just takes place in one state. Many are traffickers or savvy, and they move victims from state to state. Being part of a regional nationwide task force helps with our investigations. It helps with federal prosecutions. Our squad structure. So the child exploitation is a task force. It's 4 detectives. They exclusively investigate anything related to the exploitation of a child. So it's not just sex trafficking events. If a child was sexually assaulted, but we believe it may have been at the hand of a trafficker, our team will respond to that. If there are buyers of children that may have committed offense, we've just had one recently in Henderson where it was a stranger trying to solicit a child on their way to school. Our team responds to that 24 hours a day. In addition to the child team, my other team is the Southern Nevada Human Trafficking Task Force that has 5 detectives. We investigate any crimes linked to trafficking that have an identified adult as the victim. So again, same thing, and in a later slide, it has some of the investigations that we'll conduct. This team also will investigate any vice-related death. So if there's a death that we believe may have been caused by a trafficker or someone being trafficked, we will respond to that. We don't investigate them exclusively. Our homicide section will handle some of them. We will handle some of them, but on most, both of us are responding to those. Our enforcement squad is a squad that conducts all of our undercover operations. They conduct joint operations with our special investigations section. Should be noted, human trafficking, it's broken up into 2 categories, sex trafficking and labor trafficking. As currently composed, the vice section handles all the sex trafficking investigations. Our special investigations section handles all our labor trafficking investigations. Our enforcement teams will assist with labor trafficking investigations. Then one thing that we've done, and this has been going on now for approximately 2 to 3 years, we stood up 2 squads that are victimless proactive trafficking investigation squads. So these are squads that will go after people that have a history of trafficking, that were receiving information of trafficking, as well as victims who have given us information on who their traffickers are, but are not willing to come forward, provide a statement to us, are not willing to testify. We will never force a victim to provide a statement, to go on the stand and be re-traumatized. If they're willing to do that, we support that. Obviously, we want to arrest bad people for putting people in bad situations, but we will never re-traumatize a victim to do that. So on a lot of the cases and a lot of the information they're getting, it actually comes directly from victims of trafficking that are just not ready to take that next step and testify against their trafficker. These teams, they work on intel gathered investigations. Some of their investigations do involve undercover operations. They use a 5-prong approach. They go after people that do have a history of sex trafficking, violent criminal history, to include those violent domestic violence history, gang nexuses, firearms, and financials. And the interesting part about the financials, the reason why we're not targeting, but investigating those who have financials, as Bridget Duffy had said earlier, those monies that we seize are able to go back and help the victims of these crimes. One of the largest issues we see, and this is me speaking for the department and me as an individual, I've been a detective on this team for 12 years. I've been a sergeant now for another 4. One of the largest problems we have with getting our victims out of the lifestyle is housing. Many of the victims, many of which are women, we do have male victims, but the majority of our victims are women, find it difficult to leave the situation that they're in because they have nowhere to go. Sometimes putting someone who, even though the conditions may be terrible, there may be violence, there may be sexual violence, they may be living in what appears to be a nice lifestyle, a nice house, driving a nice car, and for them to say, yes, I'm ready to get out, but we have to put them in a shelter, it's a very difficult transition for them to make. So those financials, seizing those assets and being able to put that into resources, specifically housing, it's really important, and it's one of the things that we focus on. Our second proactive team focuses on the Johns and the buyers. That's their main focus. So they will do street level John operations. They will also do other investigations, including computer-based operations, where Johns are specifically out looking to purchase sex from children. In addition, they will go after proactively traffickers in the tourist corridor, and they will assist with unlawful brothels. These are the main type of investigations that we investigate. We do sex trafficking of a child, sex trafficking of an adult, pandering, kidnapping, sexual assaults, child luring, child pornography, shootings, battery with deadly weapons, prohibited persons in possession of firearm, domestic batteries, extortions, death investigations, and theft investigations that have a sex trafficking nexus. All of those crimes, there are other units in the department that will investigate those as well. If there is a sex trafficking nexus, though, we will take primary on that. So kidnapping is generally handled by our robbery section. So if someone is kidnapped, normally robbery is going to respond to that. If the person that is being kidnapped has a history of being trafficked or related to sex trafficking, robbery will not respond, our section will respond. Our mission and goals, it's victim-centered approach. That is our number one priority. We understand that the people that we come in contact with are victims. They are being victimized often by their traffickers, often by the buyers as well. As many of the people that spoke before me have said, they have also had prior bad experiences in their life, whether it been as a child with their family. They have high instances of sexual assault. So we understand that the people that we are dealing with have a lot of trauma that they have dealt with, and we need to recognize that and not add to their trauma as law enforcement. Myself and another detective teach every academy. This is something that we focus on, we harp on. We've spent a lot of time talking with survivors. A lot of the feedback we get from our survivors is, yes, it was terrible having a trafficker. Yes, it was terrible being bought by, individuals coming out thinking they were having a good time. But some of the worst trauma they experienced was from the uniformed law enforcement that showed up, and instead of listening to their story, taking their story, they were treated poorly all over again. We make it a point to our officers that you have to be a professional. So regardless of the context that you're coming into contact with these individuals, understand the victimization that they're in, be a lifeline for them, and maybe you'll be the first person in their life that they're like, okay, they treated me decently, maybe I'm now willing to give my statement. So it's something we really focus on in our section. As I mentioned before, we work with our advocate partners to assist victims of sex trafficking. Rise Signs of Hope come out with us 24 hours a day, as I mentioned. We also have 15 additional non-governmental partners that partner up with us. They include a gamut of things, including the Embracing Project, Shiro Foundation, Hookers for Jesus, Pink Chair. tons of community support, and they really make a difference, in getting our victims the help they need. And then what we always hope is that it hopefully leads to a successful prosecution. But number one, it's getting the victim the services that they need. Services are immediately offered 24 hours a day. We have an alert system in place for identified victims. Along with the alert system, I know one of the other presenters talked about the safe voice. So any child that we come in contact with that is in a Clark County public school, we do a handle with care. Forgive me, my allergies are kicking in, but we do a handle with care notification that is reported that this child will need or potentially could need additional services at the school. Again, we respond 24 hours a day, 7 days a week. Our goal is to identify, arrest, prosecute sex traffickers. We also, like I mentioned, proactively target sex traffickers when victims are unable to testify or have not been identified. We proactively target sex buyers, and also, which is not listed on there, is training and the education piece. We feel training and education is extremely important. Last year, leading up to Formula One, we were able to train and teach over 2,000 individuals in the community on sex trafficking, what it looks like, signs. A lot of those 2,000 people were members of hotel staff, the airport, and the buses. Some of the people that come into contact with us and may not even know what they're looking at. Year to date, we have trained an additional 2,000. So we're really ramping up the amount of training that we're doing during the year. If you have anything, just let me know. This study I added in here, this is a little bit about our victimless proactive intervention. We partnered up with Arizona State University. They came in, they looked at all of our proactive investigations over a defined period of time. The defined time that they looked was from 2021 to 2022. There were 191 investigations that resulted in 188 arrests for pandering. They broke down where most of the investigations or the arrests occurred. The bulk of it, as we would expect in Southern Nevada, it was on Las Vegas Boulevard. Some of it was on Tropicana and Boulder Highway, which unfortunately are hubs of prostitution that occur and sex trafficking occur. And the other one was the transportation hubs, the airports and the bars. And then last one was restaurants. The data they collected, what it showed is that the people that we proactively arrested, 94.2% of them had prior arrest history. 50% of them had arrest history through multiple states. They then broke down what the offenses were that their prior arrest history was for. 1 in 4 of the individuals had prior sex trafficking arrests, either from our state or another state. Forgive me as I look a little bit close on this because my eyes are bad. I believe it's over 60% had drug-related offenses, 50% gun-related offenses, 41% domestic violence offenses, 16 pimping or pandering charges, 14% child abuse, 1% sex trafficking, and then 11% sex trafficking and 4.7% prior homicide history. And again, I apologize, my eyes are not great. Also,
I'm sorry, is it your eyes or your allergies?
I got both.
Okay.
Both.
Okay. We just wanted to clarify that for the record.
I apologize to the chair. They also took a look at gang history. So 25% of those proactive arrests had prior gang history. The study showed that someone at the time of arrest with the gang history was 3.5 times more likely to have a firearm with them, and that the gang members or associates were 5 times more likely to be local offenders. And there's a full study. If anybody wants to report it, we can actually provide the whole report. That was just a little bit of a summary of what they found. Our Southern Nevada Human Trafficking Task Force, it's been around since 2006. The stats that I'm going to show on the following page are strictly stats collected by LVMPD. It's not all-encompassing for Southern Nevada. It does encompass a lot, but these are our LVMPD stats for 2023. We arrested 287 individuals for sex trafficking and or pandering. 47 specifically for sex trafficking a child, 72 for sex trafficking an adult, 168 for pandering. In addition to that, we arrested 248 other felonies. Now, these stats are not double dipped. So in a lot of instances, if we arrest a sex trafficker, they may also be arrested for sex trafficking. They may also be arrested for domestic battery, strangulation. If it was a sex trafficking and another offense, it just gets listed as a sex trafficking. The other 248 are not a sex trafficking charge attached to it, but were sex trafficking related. These include kidnapping, battery with deadly weapon, possession of child pornography, sexual assaults. To clarify the difference between sex trafficking and pandering, I'm sure most of the panel knows, sex trafficking requires fear, force, or coercion to be present unless the victim is a child. So pandering does not require the fear, the force, coercion. So those are the two distinctions with sex trafficking and pandering. We arrested, of those who were arrested, 98 of them had documented gang affiliation. We arrested and or cited 127 buyers of prostitution. 22 of the buyers were trying to purchase sex from a child. The 22 arrests, those are felony arrests. The other 105 arrests are misdemeanors. And if they don't have a prior history of it, unfortunately, a first offense is a citation. We investigated 6 vice-related death investigations. As part of our investigations, we served 292 search warrants and recovered 85 illegal firearms. For Formula One and the Super Bowl, we took a holistic community approach. We brought in the FBI, the HSI, Border Patrol, Henderson Police, School Police, North Las Vegas Police, the Attorney General's Office, Parole and Probation, and HP. We also brought in a ton of outside advocacy groups. We partnered up with It's a Penalty, which helped with our campaign and getting the word out and getting billboards out on the street. During Formula One, we were able to recover 5 juveniles. We made 36 pandering arrests. We made 31 buyer cite or arrests, and then an additional 70 felony buyer arrests. Those are, again, buyers that were trying to purchase children. During that operation, we recovered 5 firearms. For the Super Bowl, we recovered 13 juveniles. We made 39 pandering arrests, 10 sex trafficking of an adult arrest, 2 sex trafficking of a child arrest, 21 buyer cite or arrests, and then an additional 26 of the felony buyer arrests that were attempting to purchase sex from children. One of those buyers came from out of state with the intent to pay for sex with an 8-year-old child. And then we recovered 9 firearms. These are our child sex trafficking statistics. I won't go down everything, but for a basic breakdown of our victims, 54% of our child victims were African American, 22% Hispanic, 20% Caucasian, 2% Asian, 2% American Indian. As far as our adult buyers, the adult victims, I apologize, the numbers are fairly similar. 51% African American, 28% Caucasian, 8% Asian, 7% Hispanic, 5% unknown race, 0.5% American Indian, and 0.5% Hawaiian. That's our basic presentation, and we're open for any questions.
Members, any questions? No. Okay, we're going to start with Vice Chair Scheibel.
We knew I had questions, but I'll try to keep it brief because I know I stand between us and lunch. So I'll start with maybe an easy one. I was really encouraged to see that you're working with those advocacy organizations 24/7. I could be mistaken, but I don't think that was the case when I was first elected in 2018. And so I was hoping that you could kind of give us a brief history. When were you able to ramp up to 24/7? How much have you expanded the partnerships, and how many more victim advocates do you have now?
So I can answer part of that. You are correct. Initially, it was not 24/7 response. It's one of the things that we learned that we get a lot of buy-in. We get a lot of buy-in from the community. They want to help, and our victims are asking for that, right? So RISE, I believe it was right around 2019 when it went into full fruition, where they were responding with us 24/7. So we had been working towards that. We had groups that had helped with us, but it was never full-time 24/7. It was normally during business hours, but right around 2019 is when it switched over to that. They understood that it really made a difference if they were responding with us right from the beginning.
And Lieutenant Brian Boxler here speaking. I think I got to give credit where credit is due to. I think a large change in how our concerted effort really got a lot of speed with our advocate groups was when we hired on our task force coordinator. Her name is Jenna Strasser. So she's basically like the bridge between the law enforcement facet of what we're doing here with Metro and those 16 NGO groups. So she is with us in the office. She has just done a tremendous job of streamlining and identifying gaps in what those 16 NGO groups were doing, bringing people in and organizations in that would be able to help us fill those gaps and just ensure that we were being as effective and as efficient as possible with that outreach, with that maintenance, with those recoveries, those services to those in need of those.
Again, great to hear. And I know that we are not a money committee, but I am interested in not how much is invested in this, although I am interested in that as well. But my question is more about the structure of the funding and whether LVMPD is footing part of the bill for those 16 non-governmental organizations, or whether, you're depending on private donations to those organizations in order for those organizations to be able to provide so much support to your larger, overarching goals.
So our main advocate partner, which is Signs of Hope RISE, they are part of that OVC DOJ grant. So most of their funding comes from that. They do get additional funding from other places. The other partnerships are basically self-funded, and they work on donations and getting community support. LVMPD, I think the only stuff that we are actually funding is that coordinator position and the assistant coordinator.
Okay, thank you. All right. And now, the question you've all been anticipating. Could you tell us a little bit about why you're not providing statistical information to the UNLV crime statistics data the registry?
Oh, not a problem, ma'am. Do we have an opportunity to bring up that Senate bill on our screens? Are we able to all reference it or read it off, please?
Actually, what I think would be better at this point, because that's kind of a separate and not necessarily specific to this agenda item, if we could have that conversation offline.
Yes, ma'am.
And does that work for you, Senator? Okay, because I want to, make sure that we're keep flowing with the agenda and not that we get so far off. But the topic's been brought up, so we know that there'll be a further discussion. But if we could just keep questions specific, okay, then let's go ahead and do that. Members, any other questions? Okay, I don't see any additional questions. Then I'll go ahead and close this agenda item. Yep, I don't see any other ones. For agenda item 8, and at this point, it looks like we have 4 more presentations today, so I think this would be a good time to break for lunch. It is 12:30. Everyone, we will be back at it at 1 o'clock. Thank you. Let's go to lunch. Hello, everyone. I'd like to welcome everyone back to committee after lunch. Our next agenda item is agenda item 9, which is a presentation on past initiatives and future goals of the Nevada Coalition to Prevent the Commercial Sexual Exploitation of Children. We have Maria Janas, the Social Services Chief for the Field Programs Office of the Division of Child and Family Services from the Nevada Department of Health and Human Services. When you are ready, I know it may take a minute or so to get yourself set up, but please proceed when you are ready.
Thank you for that, Chair. My name is Lupi Janos, spelled Lupiejanos. I am the Social Services Chief 3 for the Family Programs Office, which is embedded within the Division of Child and Family Services, which is a part of the Department of Health and Human Services. And I will be here to present on the Nevada Coalition to Prevent Commercial Sexual Exploitation of Children, otherwise known as CSEC Coalition, reporting out on activities that occurred last calendar year in 2023, and then what's planned for 2024. Quick overview of what I'll be going over today is really just an overview of the coalition itself, coalition meetings that were held in 2023, as well as challenges and barriers that were encountered last year. We'll talk a little bit about some of the data collected that Dr. Kennedy earlier in the day alluded to, and then what our plan is for the rest of this calendar year. And then we'll have an opportunity for questions if anybody has any. So to give a quick overview of the CSEC Coalition, the first Nevada Coalition to Prevent Commercial Sexual Exploitation of Children was established by State of Nevada Executive Order 2016-14 on May 31st in 2016. In 2020, Governor Sisolak directed the Division of Child and Family Services to establish a statewide coalition going forward. So the focus of the CSEC Coalition is really to ensure and implement and develop recommendations for services, legislation, and best practices for CSEC in the state of Nevada. NRS 424.273 created the position of the CSEC Coordinator for Services, who assists in the coordination and facilitation of those coalition meetings. So meetings that were in 2023. Meetings typically were scheduled to be held quarterly. One coalition meeting was held on March 21st, 2023. 3 other meetings were scheduled, however, did not move forward. Over the past year, some of the challenges was the creation of the Human Trafficking Coalition that came out of last legislative session. It was formed, and it consisted of similar membership of the CSEC Coalition. So feedback that the division received was that there was a desire to look at aligning the 2 coalitions just to really ensure that there was no duplication in the work that was being done. DCFS has been working on this internally to accomplish that, and then we'll return to the work this year. Part of last year, DCFS administered a survey to the membership of the CSEC Coalition to collect additional feedback and to regain members' commitment to the group. Our next meeting is scheduled for May, next month, and then every other month through the end of the year, as long as that is agreed upon by the group. So I spoke a little bit about some of the challenges and barriers that we encountered last year. We had several staff transitions internally within the division. People moving out of positions, new people coming on, rotating out. It created a difficulty in those new staff learning that program role and really what the purpose of the coalition was. Also learning group dynamics for the different groups. And then challenges with obtaining quorum for the coalition itself, and then some of the subcommittees. As I spoke previously, the creation of the Human Trafficking Coalition created just some duplicativeness in the composition of the 2 groups. And so there was really, like, the feedback that we received was that there was a desire to not duplicate the work being done in each of the coalitions. There was some difficult with getting engagement with the members. Like I said, being able to reach quorum, active participation in meetings, and that such. I'm going to go into sharing just a little bit of data. So on the next 3 slides is some of the data that comes from the the Statistical Analysis Center of UNLV, which Dr. Kennedy heads and leads. This first slide really talks about just the screenings that were conducted in 2023. So in 2023, 7,593 children were screened for potential CSEC involvement. This is lower than the 10,955 screened in 2022. However, Dr. Kennedy let me know that also, it pulled in data from previous years, and that's why that number might be that high. But we do plan on diving into that a little deeper just to ensure that that's the reason. The average age in the population was 13 and a half years old, and more girls were screened in, 4,043 than boys. So the graph itself just is a breakdown between male and female, just specific to the 7,593 children that were screened in 2023. And then the screenings by region section with the text just reflects, it's the breakdown by jurisdiction of where the screenings occurred. So 85% of the 7,593 screenings that were conducted last year occurred in Clark County. 10% occurred in Washoe, and then 4% in the rural region. And then the gender ratios were the same from the previous year. This next slide just really reflects the racial and ethnic breakdown in the percentages by each of the child welfare agencies of those 7,593 youth that were screened last year. In years moving forward, we should be able to report out on SOGI information, which is sexual orientation, gender identity, and expression, because that is something that our child welfare agencies have begun to collect. And these data elements are now embedded and being captured within our case management system. This next slide talks about the actual identified victims that were found from the 7,593 screenings that were conducted last year. So in 2003, 58 children were identified as CSEC victims, and this is lower than the 115 victims identified in 2022. The graph on the right is a breakdown of those 58 victims by race. And then the regional breakdown reflects the number of victims identified in each region and their genders. So our plan for 2024. We are reconvening the CSEC Coalition. Our next meeting is next month. Our plan is to process new membership applications and calendar meetings for the rest of the year. The CSEC program itself was absorbed internally within DCFS. We now have a dedicated employee in the coordinator role rather than a contracted position that was only temporarily funded. It allows for developing really expertise to be created internally within the state and within the division, and it creates more sustainability moving forward for both the program itself and the work of the coalition. It also allows us the opportunity to infuse continuous quality improvement activities in everything that we do. We also plan to coordinate and collaborate with the Nevada Human Trafficking Coalition just to ensure that there is no duplication of efforts. That collaboration has already began, and we look forward to continuing to do that the rest of this year. We plan on updating Nevada's CSEC strategic plan and really working towards improving the quality of data that's being reported to the Statistical Analysis Center at UNLV. We plan on conducting a comprehensive inventory and assessment of current CSEC programs, what available training there is, services, and then initiatives currently active in the state. Again, really trying to make sure that there's no duplication of the work that's being done for this population. We really want to integrate CSEC objectives into our division's Child and Family Services Plan, which is Nevada's 5-year federal strategic plan for child welfare. And that does conclude my presentation, but I'm definitely open to questions if anybody has any.
All right, thank you so much for your presentation. Do we have questions from members here in person in Las Vegas? I don't see any, so we'll go up to Carson City where I actually don't see any of our members there. Okay, then we will go to the internet. Do we have any members by Zoom or other audio visual technical capabilities who have questions? Okay, I don't see any of them chiming in, so I think you have escaped the hot seat without any questions for today. And we do appreciate you being here, and we look forward to getting those updates when CSEC is reconvening and having some more meetings. So thank you.
Thank you.
That will close this agenda item, which I think is number 9. And we will go to agenda item number 10, an overview of the statewide juvenile justice programs. And I think our presenter is in Carson City. I can see her coming up to the table now. So please go ahead whenever you're ready.
Hi. Good afternoon, Chair Miller and members of the committee. My name is Tiffany Greenmeyer, and I serve as the Deputy Administrator for Administration Services for the Division of Child and Family Services. I do want to say Administrator Marla McDay Williams sends her apologies as she was unable to be here today, and Sharon Anderson, the Deputy Administrator over Juvenile Justice Services, wanted to be here today, but she is celebrating her daughter's graduation from college, and it is my pleasure to share our programs with you today. These are the areas to be covered throughout the presentation. This is our mission and vision. Chapter 62 of the Nevada Revised Statute governs the juvenile justice services for the state of Nevada, and Chapter 63 governs state facilities for the detention of children. The state-operated facilities and the Youth Parole Division are funded with state general funds. State general funds support a portion of the prevention services in the counties and the county camps. County-operated juvenile facilities and juvenile probation are funded by their respective county general funds. Counties also support a portion of the Youth Parole Division through assessments. Federal grant funds support specific programs and services statewide through sub-grants and supports compliance with the Juvenile Justice Delinquency Prevention Act, which includes one full-time employee and the Juvenile Justice Programs Office and the Evidence-Based Resource Center. Nevada has always believed that youth and adults should be treated differently and in different systems, which is why Nevada's juvenile justice system is the Division of Child and Family Services. I would like to share with you some key differences between the adult justice system and the juvenile justice system. In the adult system, the person is referred to as the defendant. The defendant is found guilty or convicted by a judge or jury, and then they are sentenced. The judge determines what the sentence is based on the minimum and maximum terms as prescribed by the Nevada Revised Statutes. In the juvenile justice system, the person is referred to as the youth or child interchangeably. And rather than a conviction, there is an adjudication. Judges adjudicate the youth as delinquent, and the judge can choose to keep the youth in their county under their local county probation department supervision or commit them to the Division of Child and Family Services. There is no determinate sentencing for juveniles in the state of Nevada. The length of stay in the facility is determined by the youth's progress in the program. The average length of stay in our state juvenile justice facilities is about 6 to 9 months. This slide outlines county versus state roles. The counties are usually the youth's first contact with the juvenile justice system. Counties try to intervene at the lowest level possible. This is considered front-end interventions. For the typical teenager, if they get involved with any part of the front-end interventions, this would deter them from getting into more trouble and going through the process again. Others may continue to engage in delinquent behavior and face more county-level interventions. But at a certain point, judges will make a decision to commit a youth to the state. State roles include newly committed youth as well as youth who continue to commit delinquent acts and their parole status is revoked. This slide shows the juvenile justice funnel. Our counties do a great job at diverting and keeping youth in their communities with their prevention services, which can be seen by the narrowing of the funnel. Their work keeps many youth out of the state custody. This slide shows the grants received by Nevada Juvenile Justice Services. Before I get into what our division does, once a youth is committed to us, I want to point out that our work is in juvenile justice and is guided by federal standards of care and outlined by the Juvenile Justice Delinquency Prevention Act. When a youth is committed to DCFS, we take into consideration that the majority of them experience some type of trauma in their lives, whether it is physical, emotional, or sexual abuse. They are coming from tough situations and many were not set up for success. Our admissions team reviews the documents for each newly committed youth and makes a placement decision based on the youth's history and needs. Most youth are appropriate for placement in one of our state facilities. They are the youth who have not been successful with the county level interventions, their delinquent behavior has escalated, or the nature of their crime causes the judge to bypass the county level altogether. Those youth are admitted to either Caliente Youth Center or Nevada Youth Training Center, which are both staff-secured facilities, or Summit View Youth Center, which is the highest security facility. Some youth are determined as not appropriate for a juvenile justice facility. These youth are youth who need significant mental health services. This is a youth who has been actively suicidal within the last month or so, with multiple co-occurring diagnoses, or has a profound intellectual or developmental disability. These youth are typically diverted to the mental health facility in our state or to specialized treatment in other states. We also have a unique challenges with youth who are in the child welfare system and in the custody of child welfare agencies, who are also committed to the custody of DCFS. Finding an appropriate place upon their release can be a challenge. These youth do not have a family home to return to, and foster care placements are scarce. Unfortunately, through no fault of their own, some remain in our facilities longer than necessary while placement is being sought. We have youth who have significant mental health needs. Our team really struggles with how to support these youth. There is a need for more community-based services options to help with their needs. Specifically, partial hospitalization programs, outpatient programs, highly fidelity wraparound services, and targeted case management. With the care management entity now underway, we are in the beginning stages of engaging them for support services for our youth prior to them earning parole status and returning to their communities. Lastly, I would be remiss if I did not share the staff vacancy rates at our juvenile justice facilities. Group supervisors, also known as GS staff, are the identified direct care staff. Our entry-level GS staff vacancy rate is 47%, as at the Summit View Youth Center, 54% at Kelly Anti-Youth Center, and 67% at the Nevada Youth Training Center. These vacancies affect our operational capacities for the number of youth we can safely serve at any given time. We are working on a budget request to assist in addressing this challenge. Once youth arrive at our facilities, it is not our job to punish them. We provide an array of services to address the needs identified. Each youth has a program that is developed specific to their individualized needs. Remember, Nevada does not have determinant sentencing for juveniles. DCFS has a programming that lasts on average about 6 to 9 months. We don't want youth in our facilities longer because we know research says that keeping them longer is not helpful to them. In fact, it impacts their mental health and does not reduce delinquent behavior. This slide shows the variety of mental health and substance use services at each of the 3 facilities. Our mental health teams work hard to address the mental health needs of the youth in our care. We continue to see high levels of mental health challenges, including youth with self-harm thoughts and actions. We serve pregnant youth through their 2nd trimester. These youth receive prenatal care and are paroled and returned to their community prior to their 3rd trimester due to the prenatal care needs being more extensive. Better for the youth committed to our care. Our facilities are in the process of becoming certified as Substance Abuse Prevention and Treatment Agencies, known as SAPTA. The goal is to be able to provide more robust drug and alcohol abuse programming in all 3 facilities. The facility staff are an incredible group of people. They care about these youth. They work hard to ensure that youth remain connected to their families while in our facilities. Due to their diligence on the job, they have been successful at intervening and saving youth's lives, specifically when the youth have had intentions to taking their own life. Our staff work endless hours of overtime to ensure youth supervision is covered 24/7. The state's family engagement plan is designed to increase the youth's family's contact with their child while they are placed in one of our facilities. When we know youth do better in the juvenile justice system when they maintain a strong relationship with their family and when the family can be involved in their treatment planning process. DCFS has a statewide plan outlining the responsibilities of facilities and the Youth Parole Division to engage families in their child's treatment throughout their commitment to DCFS. Since COVID, we have actually had more family engagement with the youth in our care as this is when we began using video conferencing for visits and meetings. When youth are committed to DCFS pursuant to NRS 62E.520 for correctional care or other facility, our Youth Parole Division begins the intake process. The youth are assessed by the Youth Parole's mental health team, and the assessments are conducted at the local detention facilities. The screenings and assessments evaluate the youth's need and drive recommendations for admissions and placements. There are two primary outcomes of the screenings and assessments. One, admissions into one of our state facilities, or two, placement in residential treatment center or other facility. I will pause here to share the division is working on a proposal to further streamline this process that will result in more efficiency for the counties, the courts, and be better for the youth committed to our care. When youth complete their programming at one of our facilities, they achieve parole status and are returned to their communities and are supervised by our Youth Parole Division. Youth on parole receive individualized case plans and supervision based on their needs, which might include a global positioning system or GPS device, substance use treatment, psychosocial rehabilitation, and basic skills training, or other services to assist them in safely transitioning back into the community. Parole counselors have the duty and the responsibility to hold youth accountable should the youth continue to engage in delinquent activity. They also provide supervision to youth who are on parole from other states through the interstate compact juveniles. For sake of time, the remainder of the presentation slides are there for your review and questions. As we conclude our presentation, the division would like to invite members of this committee to tour our juvenile justice facilities. Touring our facilities will give you a firsthand knowledge and understanding of how our division cares for the youth committed to our care. We look forward to having the ability to share our work with you. And if you have any questions, I'd be happy to answer them.
All right, thank you so much. Do we have any questions up here in Las Vegas? I don't see anybody asking questions here in Vegas, so we will go to our friends online. Do either of you or any of you have questions? All right, I see heads shaking no, so I don't think we have any questions for you today, but we do appreciate you being here and presenting. That will close agenda item number 10, and we will move on to agenda item number 11, which is our presentation on current services and future plans of local juvenile justice entities. It looks like we have one presenter here in Las Vegas. I'm not sure if we have another presenter somewhere else in Carson. I don't see anybody there right now. So we'll start down. Oh, okay, there you are. We'll start in Vegas and then we'll go down to Carson City. How about that? So whenever you're ready, please go ahead.
My name's Michael Wheelahan. For the record, I'm the Deputy Director for Clark County Department of Juvenile Justice Services. I prepared this quick synopsis of kind of what juvenile justice is and Southern Nevada. Deputy Director Bridget Duffy kind of went over some of the statistics already with her presentation, so if you have any questions after, I'm going to kind of go over those slides real quick. So I'll begin. Our mission in juvenile justice is to improve and strengthen youth and families through positive relationships and targeted programming. We have 7 divisions within juvenile justice: detention, Spring Mountain Youth Camp, probation field services, healthcare services, administrative services, harbor juvenile assessment centers, and the truancy prevention outreach program, which I'll call TPOP moving forward. Clark County Department of Juvenile Justice operates a detention center of 192 beds. From the 2023 stats, our average POP was 167 youth. This last 4 months, we've averaged 197 youth. The average length of stay is 29 days for those children that are detained in the detention facility. Over 4,113 kids were brought into detention. 50.5% were booked into detention, where the other ones would be released home based on their charges. They wouldn't make the detainment points. We do assessments of the MAZE-2, which is a mental health screening for kids to come in to see if they're actively suicidal or having suicidal thoughts. We do a detention assessment instrument. We do the YLS for the kids if the adjudication is per state law that was passed in 2017 under AB 472. We also use the NRIT, the Nevada Rapid Indicator Tool, which I believe was passed last session. So we're currently performing that on all the kids as well. Our probation field services average caseload was 51 youth back in 2023, but it's steadily climbing. We're probably closer to 65 currently. We provide drug court. We work with the judicial court to divert kids with the drug issues. We have our SOARS, which is our sexually offense assessment and rehabilitative service programs. Those are kids with those sexual offense charges. We have a duly served youth, duly involved youth is what we call it now. We brought in Robert F. Kennedy Foundation to kind of serve. Those are kind of some of our most difficult clients, are the kids that sit in both juvenile justice and in the child welfare system. So we're currently doing that. We have one of our facilities, the Spring Mountain Youth Camp. It's a 100-bed facility, and the average length of stay there is 163 days. It's kind of similar to, if you guys are familiar with Caliente Youth Camp in Elko, NYTC. It's staff secure. There's no fence. There's no cells. There's nowhere to lock a kid up, so staff have to be able to communicate with the children. We also have our healthcare services, which provides all our medical services for both our institutions, detention in Spring Mountain. We also have our mental health treatment team that provides assessment. And like I said, when we do our MAZE, if there's something that triggers in that, they would get them help to assist with their transition while they're in detention, and they would give assessments for when they get released as well. Oftentimes we do 62Cs for gun charges, so they'll make sure the reports are done for those. Oftentimes the sex offenders have a lot of assessments they have to do, so our mental health treatment team contracts a lot of the reports out, and then they're prepared and presented to the court. We have an administrative services division that is where we house all our juvenile records, and our finance units sit inside. We also have the Harbor Assessment Center. There's 5 locations currently. In 2023, the Harbor served 5,817 youth. So those would be our diversion program for some of our misdemeanors. It's not just misdemeanors. You can walk in as well. So you don't have to be on probation or be arrested to get services there. So they do an assessment and then refer you out to the appropriate service that you and your family. So it's just not the youth, it's the families as well. So that's open to the public. And we also have our truancy prevention program. Chronic absenteeism is 7 days. So they work with the Clark County School District when you have 7 unexcused absences. This past year, there was 3,572 youth in 2023 that were referred. The number will be higher this year as the more, we just started the program. It was actually during COVID, so it was kind of hard to start a program when we had all the COVID protocols in place. So I think now we're starting to get more to where we're getting into more of the schools and servicing a lot more children. The trends, when I wanted to use the 2019 data because using the 2020, 21, 22 data doesn't seem to be as relevant to me because we were still coming out of the COVID and a lot of the crime rates and everything kind of went down because there was no school. A lot of times, if you look at data for criminal justice, at the summertime, crime rates go down often. So when there's no school, they're one of our biggest referrers for juvenile justice. So when there's no school, the crime rates and referral rates will go down. But 2019, we received 11,733 referrals to juvenile justice, and 2023 there was 9,412. Part of the process too is that some of the diverted numbers of misdemeanors aren't included in that 2023 data. So because we refer some to the harbor, moving forward, we're actually changing the way we collect our data. So all those referrals will have a better number next year because they will start with our intake in our probation division, and they will end in our probation intake division. So we'll be able to track outcomes better and have a more realistic data points to look at. Detention in 2019, we detained 2,533. 2023 was 2,077. We're going to be higher than that this year. And there's the breakdown of African American Black is 45%. In 2019, 2023 was up to 52%. So that's gone up. So that's something we'll be looking at. We do look at those data points. We actually have our 2023 data book just came out, and I sent it to Diane Thornton if you guys would like to look at that later. So I sent that website. It's got 65 pages of data. If you guys would like to look at it, and you could always reach out to Joanna Jacobs if you would like to have further conversations with me about any of the data that you guys review. Our average daily pop went from 131 to 167 in 2023. This year, the first 4 months were 197. So that's not on the data slide, but I just checked it today. Our average length of stays gone from 19 to 29 days, and I think Bridget shows you some of the data before when you're looking at the gun charges have doubled, and you look at some of the car thefts have more than doubled. So the attainments take a little bit longer, especially when the NRS requires you to do the 60C evaluation. So it makes the length of stay longer, and kids don't get out as fast based on some of those charges. Spring Mountain Youth Camp, when you look at the 2019 data, African American Black was 46. 2023 was up to 64%. So it increased 8% over those 4 years. Formal probation, youth placed on formal probation in 2019 was 1,880 compared to 1,426 last year. This year we'll be above that 2019 number by the way that the trends are going. We will be higher than that. Our average monthly caseload went from 1,797 to 1,940. Average length of time on probation is 432 days, and it went up to 449 days. That's kind of a deceiving statistics when you look at some of the juvenile sex offender laws and some of the arrests. They usually stay on a little bit longer. So you have kids that do come off probation in 6 months, a lot of them, but you've got some of the juvenile sex offenses that actually sit on probation up until the age of 21. The 10 top filed offenses Bridget went over, so if you have any questions on that, feel free to ask after. The challenges, so some of the biggest challenges we have is kind of a nationwide problem with staffing. We're budgeted for 417 positions. We have 90 vacancies, and we have 54 probation officer vacancies currently. We have 3 probation officer academies this year. We've already done 2. Actually, the second one's going to start in 2 weeks. We have another one planned for September. We have 9 scheduled to start in 2 weeks. It'll go through the academy. They're 10-week academies before they hit the floor. We were approved for a critical labor shortage designation by the Clark County BCC, which means that we can bring back some retirees that want to come back and they can collect the PERS and work for us at the same time. So we have some of the individuals lined to start that pretty soon. So we're working towards getting more people, but nationwide it's hard to get people in some of these positions. As you see with fire, they're doing advertisements on TV commercials and stuff, which I never saw when I was a young man, which quite some time ago. So, and then one of our biggest challenges, as the state knows, is limited mental health providers and services for some of the kids with the deeper end mental health issues. So, any questions, feel free.
Thank you. I think we'll go up to Carson City first and then do questions after that. So if we have, is it Ms. Flores up there? Please go ahead whenever you're ready.
Thank you. Vice Chair, can you hear me? Hi, my name is Liz Flores, and I'm the Director of the Washoe County Department of Juvenile Services. Thank you to Vice Chair Scheibel and the committee for allowing me to make this presentation today. Oh, thank you. So we conduct our operations from the Jan Evans Juvenile Justice Center located in Reno, Nevada. For those who are not aware, Jan Evans was a former assemblywoman who was an advocate for children in both the dependency and delinquency arenas, and we're very thankful to have her name on our building, and she's an inspiration to us and guides. Her work continues to guide us to this day. This particular slide reflects our philosophical underpinnings. However, it was already covered by our Chief Deputy District Attorney, Shelley Scott, earlier today. But we've incorporated the balanced approach, as well as we had been selected as a site of the Juvenile Detention Alternatives Initiative in the early 2000s, which was sponsored by the Annie E. Casey Foundation. My only addition to this would be that during that era, that is when we really shifted toward data-driven decision-making, focusing on evaluating racial and ethnic disparities. We looked at our conditions of confinement in our detention centers and also explored deeply alternatives to detention, which have now resulted in a significant reduction in the number of children who are placed in our detention centers. You've also seen this juvenile justice funnel twice already today, so I won't go through it other than to just highlight that we make an effort in juvenile justice through a series of evidence-based practices to divert as many children as we can who are entering our system in the hopes of really narrowing and limiting the number of youth who are ultimately removed from their home into county camps, state corrections, mental health treatment facilities, if we can prevent that, and also avoid certifications to the best of our ability. So a lot of our efforts and resources go towards the diversionary part of the funnel. This is our department. We operate under the authority of Chapter 62 or Title 5 in the Nevada Revised Statutes. We also are under the administrative oversight of the 2nd Judicial District Court. We have our administration, our detention center, which is called Wittenberg Hall, probation, community services, traffic, and clinical services. Our detention center, called Wittenberg Hall, which is housed inside of the Jan Evans Juvenile Justice Center, opened in 2004. It is named after Helen Wittenberg, who was a champion for juvenile rights in the 1940s all the way through the 1960s. And for that reason, our detention center within the facility bears her name. We have 108 beds, a medical clinic. We have a Washoe County School District on site, food and nutrition services, mental health services, and we have recreational and educational activities for the youth in our care. Our probation services are comprised of an informal supervision unit and a probation assessment unit and supervision units. Our informal supervision unit manages the vast a number of referrals that come through our agency, which are misdemeanors and status offenses. Our probation assessment unit assesses all felony and gross misdemeanor referrals that we receive. For those youth who do get court-ordered to probation, court-ordered supervision, we assign them either to our compliance unit or one of our specialized probation units that you see here. We have a sexual behavior unit, a gang unit, and our gang unit is part of the regional gang unit in the north, behavioral health unit, the China Spring and Aurora Pines youth camps, and a substance abuse caseload unit. We also have our community services that operate our youth development programs, as well as an evening reporting program that we've had for over 15 years in partnership with the Boys and Girls Club of Truckee Meadows. In that program, our staff pick up youth from school daily, deliver them to the Boys and Girls Club where they participate with them in pro-social activities, and then return them home in the early evening hours. We also have a work crew and a youth development program. These next several slides that show statistics have a general theme that show that since the 1990s, there has been a significant decline across many measures nationally and locally related to juvenile justice. You can see here in 2009, we had over 7,000 referrals, and if we were to go back further in previous years, they exceeded 10,000 referrals. So you can see the decline in the number of referrals. It did dip during COVID, but you can see that those numbers are rising. And last year we had over 2,800 referrals. Our Wittenberg Hall statistics show that our average daily population, if you look in the left column at the bottom at 2019, prior to COVID, our average daily population was in the 40s. It declined during the pandemic, and you can see that the last several years has been increasing again. Our average length of stay, when we look from the time of booking till the time they exit our detention center, ranges between 14 and 19 days. But we also calculate from the amount of time that youth stay on average after their detention hearing, and that number's nearly double. So that ranges from between 30 to almost 40 days. This next slide shows our placements. On the left side, you'll see our residential placements. The blue columns are the in-state residential treatment centers, and the purple are the out-of-state residential treatment placements for youth. Unfortunately, I don't have the totals here, but if you were to look at 2023 total residential placements compared to 2019, you'll see that that number is greater. So in 2019, the total there is 52 youth were placed in residential treatment. And in 2023, it's actually not surpassing it. It's a total of 46. However, you can see that we're increasing at a significant rate for the number of youth who are being placed in residential treatment centers. The next graph shows state and county commitments. Over the last 5 years, the blue line shows our state correctional placements as ordered by our court, and that number is relatively static with the exception of the COVID period. The purple lines are the county camp placements at the China Spring Youth Camp and Aurora Pines Girls Facility, which has fluctuated over the years, primarily due to a reduction of beds due to budget constraints. This next graph shows outcomes. On the left, you'll see a 2023 case snapshot to capture the percentage of diversion cases that we had. So 75% of all cases in 2023 were diverted from court or closed with informal sanctions. And on the right, you'll see our reoffense rate for felony and gross misdemeanor offenses when we tracked kids who were on probation for 24 months. So from 2021 to 2023, 76% of the youth we supervised had no reoffenses, 19% had one reoffense, and then you can see the smaller numbers along in the pie chart. As we speak about challenges in the juvenile justice system that we're experiencing, it's known by most, if not all, that the CDC has reported an increasing number of adolescents who are reporting struggling with mental health issues. In the juvenile justice population, studies reflect that specific to youth in our system, they experience far more adverse childhood experiences or ACEs or traumatic events in their life than youth in the general population. The youth that we serve who are in most in need of services are those who demonstrate high levels of aggression and noncompliance related to a mental health condition, those with intellectual, neurological, and developmental disabilities, youth with mental health conditions or intellectual challenges who are found to be incompetent to stand trial, detained youth are at high risk for suicide attempts, and youth with mental health symptoms that lead to arrest. As such, in the juvenile justice system, we act as a mental health agency by navigating placements, brokering assessments, case managing treatment, and also housing youth who are awaiting treatment, sometimes for extended periods of time. On any given day in our detention center, 60 to 70% of our youth suffer from severe mental health diagnoses, and many are prescribed psychotropic medications. The primary barriers we face include a lack of quality residential beds for both acute and long-term care, as well as challenges with Medicaid reimbursement rates. However, we have a positive outlook. In 2022, Washoe County purchased the vacant West Hills property that will be developed as a multi-use mental health facility. Very recently, the Interim Finance Committee approved $14.5 million in funding towards the facility upgrades of that property. Nevada Medicaid is addressing provider reimbursement rates and recently shared that they are reviewing Medicaid expansion for incarcerated juveniles, which would very much expand treatment opportunities and access for youth in our care. These coordinated local and state measures are promising steps towards providing a meaningful continuum of care for juveniles. The next challenge I wanted to highlight was regarding concentrated cannabis. If you look to the graph on the left, you will see that there was a significant spike in the number of unlawful possession of controlled substance referrals that we received in Washoe County specific to concentrated cannabis. And this is concurrent with the legalization of marijuana and the opening of dispensaries in our communities. Of all the felony referrals, female felony referrals that we received in 2023, 74% were for concentrated cannabis. And almost half of the felony referrals we received for males, 47%, were for concentrated cannabis. We did a review over a 12-month span of time of the youth that were referred for specifically concentrated cannabis and found that 63% were determined to be low risk on our YLS, which is a statewide risk assessment. 88% at the time did not have an open active case with us. 60% had no prior involvement with our agency. But we're thankful that in January of this year, we entered into a memorandum of understanding with the Washoe County DA's office to address this significant increase in the number of referrals for these offenses. And by doing so, we were able to expedite assessment, intervention, and accountability for these youth. And I believe Chief DA Shelley Scott already shared information related to this memorandum of understanding. There's still a lot more work to be done in this arena. However, under this agreement, we have already afforded diversion opportunities to a large number of youth who have been referred to us for these offenses. With that, I conclude my presentation and am happy to take questions. Thank you.
All right, thank you so much, Ms. Flores. Are there questions for either of our presenters from our colleagues here in Las Vegas? Okay, I don't see any, so we will go to our colleagues online. Do you have any questions for our presenters? Okay, I'm not seeing any questions. Oh, I'm sorry, there is one. Go ahead, Assemblymember Gray.
Sorry, I actually have a couple questions real quick. First of all, the slide you had up there that showed the decreasing referrals, that's inversely proportional to our population. How do you explain that? How do you explain the drastic decrease in referrals when our population up here, especially, have skyrocketed? And then also, you on the race, is there a way to get that broken down by crimes by race also for those detained?
This is Liz Flores for the record. Are those questions for Clark County or for Washoe County?
I'm sorry, the breakdown by race is for Clark County, and then for Washoe County, the number of referrals question.
Thank you. This is Liz Flores for the record. I will make an effort to answer the question regarding what is driving the significant reduction in the number of referrals, not only locally but nationally. The answer is there are a lot of hypotheses related to that I could attempt to prepare and put into a report for this committee's review. But the theories are that it's related to change in juvenile justice laws, It's related to changes in police practices. The economy has an impact also on the rate of referrals. I recently read an article that the number of school age youth in Washoe County has been decreasing, and there may be an impact as well in that regard. There's something I'm sure related to the transitioning of people moving from community to community. That's about my best response right now at this time, but would be happy to put together something for your review.
Thank you.
Mike Wheelahan for the record. So to kind of elaborate more on what Director Flores says, there's been some legislative changes, not just in Nevada, but even federally. When you're looking at some of the status offenses that used to come to juvenile detentions and be referred to us, and then when you're talking curfew, runaways, things of that nature, and then you're also talking truancy, traffic tickets, some of those things that have changed legislatively over the last 15 to 20 years. That's part of the JDAI initiative that Director Flores referred to, as we're one of the sites as well. So, and then as far as the racial breakdown on your question, as far as by crime, if I sent the data point to Diane Thornton with a breakdown where you can click on that link, and it has 65 pages, which will break down that data for you.
Thank you. I appreciate that, buddy, guys. I just because we know that, I mean, I haven't seen it says, especially in Washoe County, populations going down. I know in Lyon County and the other surrounding counties, it's going up, but it just kind of strikes me as odd that it's inversely proportional to the amount of referrals. I mean, we know crime's not going down. We see it every day. So it really makes me concerned as a society, not on law enforcement, but as a society, we're just kind of maybe turning a blind eye to some of these things now that should be addressed. So, but thank you guys very much for the presentation. It was very informative.
All right, agreed. Thank you so much. Anybody else have questions? Okay, I'm not seeing any, so we will close agenda item number 11. We've already had agenda item number 12 at the beginning of the day, so we will move now to agenda item number 13, our presentation from our public defenders in Washoe and Clark counties. And I see our presenters at the tables in both Las Vegas and Carson City. So let's go the opposite order this time. We'll start in Carson City and then come down to Las Vegas.
Good afternoon, Vice Chair and members of the committee. My name is Stephanie Cook, Stephanie, last name Cook, Cook. I am the Chief Deputy Public Defender of the Juvenile Division at the Washoe County Public Defender's Office. I would first of all like to thank everyone on the committee for inviting me to come to Carson City today and present in front of you all in regards to what we do in Washoe County at the Public Defender's Office on behalf of youth involved in the juvenile legal system. In our office, there are 3 attorneys who represent youth who are accused by way of a petition in the juvenile legal system. You heard from earlier presenters today about a lot of cases that are funneled and handled informally without the courts being involved. In our office, we do not become involved in those cases unless and until the district attorney uses its discretion to file formal charges by way of a petition. So there's myself as the chief, and then I have 2 deputies that work with me in our office. We also have 2 legal assistants that support us. However, they also support a felony criminal chief, our appeals department, 2 criminal line deputies, and our adult hospitalizations. And then we also share our investigator with the misdemeanor team in our office, and so that investigator is shared among approximately 10 attorneys with full caseloads. You heard earlier a little of the history of the juvenile justice system in the United States. I believe it was Chief Deputy District Attorney Scott who spoke about In re Galt, which was the United States Supreme Court decision that provided certain protections and due process rights to juveniles if they are accused of committing delinquent acts. Part of that decision is what ensures that any juvenile who is accused in court of committing any delinquent act is appointed an attorney. Because children are presumed to be indigent and cannot afford to hire their own attorney, then our office is appointed on every single case that comes through. Obviously, parents may choose to hire private counsel, and then we do have conflict cases that must be distributed to the alternate public defenders or our tertiary contract attorneys. But as a starting point, every single petition that's filed does come through our office. Our role in this system is to ensure that the young individuals who we are representing are receiving fair and appropriate representation. It's very important for us to make sure that we are specializing in those unique needs that children do have. We've heard a lot today about the different levels of developmental maturity and brain development, and so really making sure that as defenders of children that we really take to a lot of training and understanding of how that brain development may or may not affect their ability to participate in the legal process, as well as understanding what is expected of them moving forward. And really, you've heard also the overarching goals and principles of the juvenile system is to rehabilitate youth. So really having that understanding of how services can be accessed in our community in order to ensure that those goals are met and not, and ensuring that our system is not a punitive one. Here is a quick snapshot of our caseload from 2023. So we have our cases created. So those are new cases that were opened in our office in 2023. The reopened cases are cases that were closed and then may have been reopened due to review hearings or different hearings that come up, perhaps due to non-compliance with probation terms once the case has been disposed of, or things of that nature. So you can see there in the table the breakdown of the number of cases that we handled last year. As of last week, we currently had 235 open juvenile cases in our office. They are split, as you can see, pretty much evenly among the 3 of us. And that is the way that our office is currently operating, even as the chief, with obviously other supervisory and other duties within the office. I still assume a full caseload within the office just due to what our staffing levels and needs are. So in addition to our juvenile caseloads, we also handle and cover any discretionary and automatic certifications throughout the entire process. So I know some offices, if a youth is certified, whether that's through motion practice or if it's an automatic certification, that case is handed off to an adult criminal attorney. However, in our office, we keep those cases with the juvenile attorneys because of what I mentioned earlier in terms of having that specialized knowledge and understanding in dealing with people who are under the age of 18. We also assist our office in covering parole revocation hearings here in Carson City in front of the parole board. Those hearings occur twice per month, but we handle half of them. We split that duty in our office with one of the other departments. We also serve as backup coverage for our misdemeanor attorneys. So if they're short due to vacations, illness, or other responsibilities in the office, such as trials, we provide coverage for them, and we also serve as backup coverage for the justice court, specialty courts as well. And then we also have some of the more experienced attorneys in our office, and so we do from time to time serve as co-counsel for adult criminal matters to assist some of our less experienced attorneys navigate the jury trial process. As far as what we have determined to be some of our most important legislative priorities for this upcoming session, the first of which is ensuring that juveniles' Miranda rights are fully protected in the best way possible. As the committee is aware, anyone who is accused, whether it's an adult or a child, does have a Fifth Amendment right to not incriminate themselves. I'm sure we're all familiar with the Miranda warning and its basic concepts and contents to ensure that if someone is subjected to a custodial interrogation, that they are fully apprised and aware of what rights that they do have. This body has, over the past few sessions, taken some steps to bolster the juvenile Miranda. First, in 2021, the legislature did codify specific language that must be used during a custodial interrogation of a juvenile. And then last session, a law that has not yet come into effect, but will on July 1st, prohibits the use of false statements or promises of leniency by law enforcement during those custodial interrogations, basically stating that if that conduct occurs, then it's presumed that the statement was not voluntary. So obviously the legislature has already recognized that young developing brains are different than adults are. In contrast, in the adult world, there isn't a specific warning that is required. As long as all of the pieces are there, it's deemed to be constitutionally valid. However, as I mentioned, we do have codified specific language for juveniles. And so because of all of the research that does exist in regards to developmental maturity, perhaps a lack of understanding of what the words are, a lack of understanding and appreciation for potentially the gravity of the situation that the youth is finding themselves in, or the potential consequences of any statements that they do make, really, again, not having that full ability to appreciate and understand and think of long-term consequences of their actions. What we would propose is that youth who are under the age of 18 should have the ability to consult with legal counsel to assist in their understanding of their rights and consequences of waiving those rights. So what that would look like would be before any custodial interrogation could take place, unless in specific situations of exigency or needing to get information specific to an immediate threat of harm or violence, that the youth would have counsel to communicate with prior to deciding whether to engage in that questioning by law enforcement. And that consultation with the attorney would be required and could not be waived by the child or their parents. The next issue, and you heard a lot from both Juvenile Services in Washoe County, from Director Flores, as well as from Chief Scott from the District Attorney's Office, in regards to felony possession of controlled substances charges for concentrated cannabis. Most often these are cases in which a child is caught in possession of a vape device containing concentrated cannabis, most oftentimes on the campus of the school that they're attending, and they are cited by school police, and that referral makes its way to Juvenile Services. Prior to that memorandum of understanding that you've already heard about, because it was a felony charged, their juvenile services did not have discretion to handle those cases informally. And so they were always being filed on, and the youth did have to go through the court process. While we definitely appreciate all of the hard work that Juvenile Services and the Washoe County District Attorney's Office has done in order to come to that memorandum of understanding to divert a large percentage of those cases from being formally within the court system, we propose to take that one step further to codify that in statute so that if a child is deemed to be in possession of 1/8 of an ounce or less of concentrated cannabis, and I got that weight from what's contained currently in NRS 453 in regards to what is a felony for an adult to possess. So if an adult is in possession of more than 1/8 of an ounce, it is a Category E felony, and so that's where I got that measurement from. If it is a first or second offense, that it should be treated the same as a child who commits an alcohol or marijuana offense pursuant to NRS 62C.073 and 62E.173. So what that would look like is that the child would be cited, referral would be processed. However, for a first or second offense, it would deem to be a child in need of supervision as opposed to a delinquent offense, and in that case is required to be handled informally. So again, taking what has already been put into place with that memorandum of understanding, but making it statutorily required. Therefore, if sometimes we see situations where a youth will meet with juvenile services for that initial assessment and may have some concerns about what's contained within the police report, or may have some concerns about having a quote-unquote felony on their record, and so may not wish to move forward with an admission pursuant to that that memorandum of understanding where their case would be handled informally, and then the petition might get filed, and in those cases, they would still have to come to the office, their parents taking off of work, them missing school, coming to the office and meeting with us for an hour to review all the facts and circumstances and their rights and their evidence, and then, potentially still having to go to court and going through that whole process when anecdotally, and I apologize, I don't have the numbers since the January 1st MOU went into place, but anecdotally, a large percentage of those cases do result in informal handling anyway. So again, just trying to cut out a lot of those extra steps. You saw the statistics from Director Flores about how a lot of these youth are low level on the YLS, how a lot of the time it is their first referral and they don't recidivate. So really trying to, again, because the goal is rehabilitation and not punitive, to try to take out as many steps in the process for the youth and get them those immediate consequences and learning, how to make better and healthy choices to move forward. And while a vast majority of youth are just cited for that case, for these types of cases, I did recently have a youth who was actually arrested by Washoe County Sheriff's deputies out of Incline High School and transported down Mount Rose to Jan Evans. Because of the weather, even though he was cleared for a straight release, his mother wasn't able to make it down Mount Rose to pick him up, and so did have to spend the night in detention and attend a detention hearing for a case that is now going to be handled informally with him doing a substance abuse prevention class. So again, that's an anomaly in these situations, but still it just shows the amount of time and effort that sometimes goes into the cases and the trauma that can happen, right, for any youth who's charged with a felony and have to go to court and meet with an attorney. So really trying to avoid that in these first or second time offenses. Our next priority for the next session is to ensure that the juvenile court has discretion to refer a case for informal supervision regardless of the level of offense. So the way that the Nevada revised statutes is currently written and has just very recently been affirmed by the Nevada Supreme Court is that if a youth admits to a gross misdemeanor or a felony offense in court, that the district attorney must give its consent in order for the judge to refer that case to be handled informally. What we are requesting is that because it is potentially a final disposition of the case, that if based off of information provided by Juvenile Services, the District Attorney's Office, the child's attorney, the child's family, if the court in its discretion believes that there does not need to be a higher level of supervision or intervention for the child, that the court should be able to make that determination as the judicial officer overseeing the court and juvenile services to handle that case informally instead of needing the permission or approval of the state to do so. And then another concern that we have is in relationship to Adam Walsh requirements for youth who are adjudicated for sexualized behaviors or sexual offenses. Currently, certain youth, depending on age and the nature of the offense and the disposition, are required to register as sex offenders just the same way that an adult who is convicted of a sex offense is required to register as a sex offender. There is significant research by treatment providers who specifically related to the treatment for sexual abusers. So the Association of Treatment for Sexual Abusers has recommended that based off of the nature of, again, the differences between children and adults, that policies that subject children or adolescents to sex offender registration and notification requirements and related residence education and employment restrictions should be ended. So that is based off of the fact that there is very low recidivism for children who are adjudicated for sex offenses. There's research regarding the fact that interventions and sex-specific treatment goes a long way to ensure rehabilitation and to reduce recidivism, prevent sexual abuse, and is sufficient to protect the community. And so what this particular document from that organization opines is that based off of all of the research, that these sex offender registration and notification policies actually do more harm than good. Again, the goal of juvenile services is to provide rehabilitation, not to be punitive. And so in recognition of that, that we would like to take steps forward in getting rid of the sex offender registration and community notification requirements. And then finally, as everyone has said, I think, even though this is not a money committee, the biggest issue for all of us stakeholders is the lack of funding, the lack of resources, the lack of behavioral health care, mental health care, educational services. It runs the gamut, and especially when we're looking at the purpose of the juvenile legal system, that without these services in place, what we are looking at is deeper and deeper penetration into the juvenile system. We have a very good working relationship here in Washoe County among all of the stakeholders, really trying to work together to provide the treatment services and resources to children and families to ensure that they get what they need in the least restrictive way possible. However, without adequate funding for evaluations and for services and for treatment providers, especially here locally in Washoe County, really wanting to look at how do we provide the services necessary while keeping children in home, if possible. If it's not possible to keep them in their residence, at least keeping them in their communities so that they can continue to have their supportive relationships with their family, regular family visitation, things of that nature, and so that they're not, removed from their community for significant periods of time, placed out of state, and, having all of those added traumas in their lives just because we don't have the services available here. Not only do we have that issue with not having treatment here locally and needing those, but it also leads to a lot of the times deeper penetration in the system because the system ends up at a loss. We don't have any way to treat the youth in the community, and so a lot of the times then we're looking at sending them to camp or we're looking at sending them to a state commitment because there are no other alternatives to treat what needs to be treated. And that concludes my presentation. Thank you again for your time.
Good afternoon, Vice Chair and the entire committee. My name is Jennifer Fraser, Jennifer, Fraser. I am the team chief over at the Juvenile Public Defender's Office at Clark County Public Defender. I supervise the entire office, including the support staff. I've been with our office for 17 years, primarily at the Juvenile Division. We are appointed to represent all children who have a petition filed in court, whether it's a misdemeanor, gross misdemeanor, or felony offense. Unlike other jurisdictions in other states, our office also remains as counsel for kids that remain on probation, because issues like post-dispositional, so post-sentencing, when issues come up like placement issues, restitution issues, so we remain on cases. As you saw in other presentations, some kids remain on probation for quite some time, so our office will remain with those clients. We are appointed in most cases in Clark County. However, there are often conflicts because kids get in trouble together. So the Office of Appointed Counsel with the county have 8 attorneys that have contracts. So they are appointed, and also families occasionally hire private counsel. We have 13 attorneys in our office, including myself. We have 3 attorneys who are devoted solely to handling certifications in juvenile sex offenses. That's a more specialized area of practice. We have a lot more of those up down in Clark County than up north. We also have a dual involved youth calendar. So I have an attorney handling that specific milieu as well as helping out with certifications. I found that to be incredibly helpful to have one attorney assigned to those cases as those kids return to court often, so it's good for them to see a familiar face. We have 8 regular delinquency team or attorneys on those teams, including one of your own, Senator Orenshaw, is assigned to handle regular delinquency cases. And the teams, we kind of rotate and handle different specialty court assignments. We have 2 investigators. We're lucky to have 1 social worker and 6 support staff. This flow chart's a little different from the funnel that you've seen a few times today. Just to point out, it's the same information you've heard throughout the day, but the points that are like the dark red highlight, that's where we're present. So I just wanted to highlight like the front end of the process. We're not around, hopefully, if Washoe County's requests regarding counsel during the interrogation process, then we would be further or earlier in the process. But for now, we're present at all of the hearings that are highlighted. And those don't mean that those are just one hearings and done. Oftentimes we're returning to court multiple times. So we're in court when you're, oftentimes when I have attorneys in our downtown adult office ask about like the differences between adult and juvenile, And even over the years of my career, the numbers have gone down because of really positive juvenile justice reforms and diversions, but we're in court a lot. Because you can see all these types of hearings, and there's more reporting requirements and hearings that are set. So all positive things, but we are in court quite a bit. Some specialty courts that our office handles include drug court that meets weekly. I handle that specific calendar. We have JSO calendars. Each district court judge has their own handling that. As mentioned, we have the dual calendar, so that's kids who are both in DJJS and DFS. That's a really important calendar because those kids have both their cap attorney and their public defender present, and their whole team is present. So it's a way that we can get all of the information and the team approach. And I feel like a lot of feedback since we've started this is that kids feel really empowered and they feel like they're part of this process. So that's always a positive for us as their counsel. There's also a domestic violence program. We don't appear in that because there's not any, it's just like a check-in court, but that is something that our courts in Clark County do. And then day court, which we have an attorney present, and that court meets weekly as well. I wanted to present, I've presented 2 different times in front of the interim committee, and I always present our statistics on certification cases and JSO cases, so significantly higher than what we have up north or what you've seen up north, but the certification numbers have stayed relatively static, and then juvenile cases have, sex offense cases have decreased a bit over the last few years. When looking at the racial disproportionality of our certification cases, I know when Assistant Director Wheelahan, he had some breakdowns regarding overall cases. This is just a breakdown based on my own record keeping of the cases so this isn't all of the certification cases. This is the certification cases that our office is appointed to, the 2023 and 2022 data. But if you look compared to what our Clark County population is, there's over proportionality for our Black youth and our Hispanic youth. 44% of all certifications in 2023, and then 50% in 2022, when the census data is about 13.8%. So there's a huge issue with the disproportionality. And again, certifications are when the state is seeking kids getting escalated into the adult system. So this is a serious issue, obviously. Just to talk about some of I know other presenters have done so, but some of the reviews from 2023, as Washoe County just presented, we don't have any data or anything to discuss because the law that prohibits law enforcement from making false statements, that doesn't go into effect till July 2024. So hoping to have more information on that in the future. SB 411 did create autism programs. I'm not sure if any other programs have been developed in the state, but ours is still doing really well and offering services to kids and, more importantly, to their families. And then SB 415, this was the law that set probation term maximums. This was something that I was really proud of during the 2023 session, as our state didn't have any set terms. So kids as young as 10 and 11 could have been placed on probation until they were 21 for really minor offenses. So that it's such a positive change for us. Of course, I think the district attorney from Washoe County said there might need to be things revisited with this, and I agree with that. Once sometimes laws go into practice, then you see things that might need to be tinkered with, but overall a net positive, and looking forward to working with our justice partners on that. Looking ahead in 2025, one request that our office would have is to request legislation that limits unclothed searches, or also known as strip searches, of kids at local detention facilities, regional facilities for the treatment and rehabilitation of children, and state facilities. So I put all 3 of those facilities, and I'll get to that in my next session, but throughout the NRS, all the different facilities are defined very differently. And so the local detention facilities is like our juvenile detention or Jan Evans up north. Regional facilities is Spring Mountain Youth Camp and China Springs. So kids are still on probation when they're at those facilities. And then you have the state facilities where kids are committed. And then ultimately when they finish the commitment, they're on state parole. So I think there needs, or our office would like that there to deal with this issue and provide for a law that affects all of the facilities so that there's consistency within our state. In research for this, I did note that there's a DCFS policy that is pretty close to matching the ABA 2020 resolution that urges local, state, federal governments to prohibit strip searches, but I didn't see any such policy for any other facilities. And so I do think for consistency, I think whatever county kiddo is from, whatever facility he goes to, whether it's detention or a regional or state facility, I think he or she should have those protections. The ABA, I included that as a supplemental, so you can review that. I don't need to go over that in detail, but it does list some of the limitations that it's kind of a last resort that a strip search should be used. One of the primary reasons is that obviously it's triggering for any kid, particularly kids that are in their adolescence are particularly sensitive about their bodies and those issues. Also, it's an extra layer of trauma for kids who are victims of sexual abuse. Sadly, a lot of kids in our system are. So that's just another layer of trauma that we're adding on. So if there's anything, I think that we need a consistent law prohibiting or really limiting what can be done in those circumstances. Also, to kind of piggyback onto that, trying to focus on consistency within our NRS. The beginning years of my practice in delinquency court, we had one district court judge. And one district court judge meant we kind of all knew what to expect. We all knew what the his interpretation of the laws were, and we had a way of doing things. Since his retirement, we've had different district court judges. We now have 2 district court judges, that will be rotating out. So new judges means new interpretations of the law, new policies, new procedures based on existing law. And it's been a really good opportunity for us all in part of the system to take a look and go to the Nevada revised statutes and see what needs to be worked on, because a lot of those statutes haven't been amended since 2003. So I think it's an excellent opportunity to take a look and focus on the consistency. For example, when looking at statutory and due process requirements for both commitments to state facilities and placements at regional facilities. The requirements for those 2 things are different. The effect on a child is the same. The child is removed from home and placed at a camp for 6 to 9 months, which is a probation facility, or he or she is placed at a state commitment facility for 6 to 9 months. So the process to get that child, like the court process and the due process, should remain the same. They should be entitled to a hearing. They should be entitled to having reports completed. But the NRS isn't consistent in that way. So I think so. This isn't a criticism of any department or a probation facility or a state facility. It's just us wanting to make sure that our clients, our kids, have the same process when they're getting removed from home and getting placed at a camp or a state facility. And then lastly, this goes back to my data about the certifications. It is our goal. We would like to reduce the number of children certified to the adult system. There was testimony earlier today or a presentation about the facility up north that houses kids under 18 and that there's positive things about that facility. And I don't doubt that there are. But I don't see that as a net positive. I still think we need to get kids out of those facilities, kids under 18. And I think that means taking a look at our certification statutes. Current law allows for certifications of 14 and 15-year-olds for most felony offenses. So it can be something that's a nonviolent offense, and theoretically a kiddo could be, the state could seek certification. And yes, it's true, the presentations earlier, that ultimately it's a court's decision to certify, but the discretion ultimately lies with the state, and it's pretty unfettered discretion for them to be able to decide which cases to put in front of the court. So if we could limit the age range, move it up to 16 years old, perhaps limit the type of offenses where the prosecutor's office can seek certification, limit to violent offenses only, offenses including a firearm, and then also prohibit the state from seeking certification for first-time offenders. And I didn't include that as data, but I can provide it if needed. But a lot, looking at the past few years, there's a significant amount of the kids that are coming in on their first petition, their first touch with law enforcement, and the state seeking certification. So those kids don't have any prior in community services. They don't have any prior probation services. So I think that's an area where we can close the loophole, and that hopefully in reducing these types of numbers, that would also affect the disproportionality discussed before. And I just wanted to co-sign what all of the other partners have talked about, needing more mental health services in community services, and certainly support Washoe County Public Defender priorities as well. Thank you.
Thank you both so much for your presentations. Are there questions here in Las Vegas? All right, Senator Harris.